ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಕೇಳ್ತಾ ಇದೆಯಲ್ಲ ಪೋರ್ಟಲ್ ಇಂದ?
ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ.
Okay. Just 1 moment. List. State change ಮಾಡಿ ಇನ್ನ ಸೈನ್ ಆಗಿಲ್ಲ. ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ಅಂದ್ರೆ ಎಲ್ಲಿ ಸ್ಟೇಟ್ ಯಾರಿಲ್ಲ, ಇದು 2 ವರ್ಷದಿಂದ ಆಗಿಲ್ಲ. ಕೊಟ್ಟಿದ್ದಾರೆ. Withdrawing 30 13 na 30 na 30. The counsel for the petition has filed a memo dated 14/6/2022 seeking for permission to withdraw the above matter. With liberty ಏನಿದು ಶೋ ಕಾಸ್ ನೋಟಿಸ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ? Seeking permission to withdraw the above petition. The above petition has been filed challenging a show cause notice. Now the petitioner has replied to the show cause notice. He seeks for liberty to challenge the order if any passed against the petition. Reserving such liberty, the petition is dismissed as withdrawn.
Number 1, page number 4, serial number 21. Page 5, serial number 22 to 29.
So who is going to appear in the matter? 27. It is submitted that Shri Chandrasekhar L has entered appearance for the petitioner. Registry to verify and print his name as that appearing for. Kiran Kumar and Prostada. Is on. Print his name as that appearing for the petitioner and delete the name of Shri Kiran Kumar. Relist on 28/6.
Page 6, serial number 31 to 42.
Lord, serial number 35, my lord. Lord, serial number 35, my lord.
This is only Krishnan.
35, my lord. I appear for the respondent. 2 weeks, my lord. File statement of objection.
Just one moment. First, yes, Mr. Krishnan.
Serial number 35, my lord. For 2 weeks.
Number?
35, my lord. I am for the respondent.
35. Have you filed your objections?
I have not filed my objections, my lord.
Have you informed the counsel for the petition?
I have messaged him, my lord. I'll also call him once again and inform him. He was not picking the call, but I will inform him. And take inform him.
ನೀವು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತೀರಾ ಅಂತ ಪಿಕಪ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
But next time ಮಾಡ್ತೀನಿ sir.
Uni Krishnan seeks for and is granted 2 weeks time finally to file a statement of objection. Objections, if any, to be filed on or before 1/4/2022, released on 1/7/2022, released on 5/7/2022. It's made clear that no further adjournment would be granted.
Page number 7, serial number 43 to 53. Page number 8, serial number 54 to 63.
Hmm. Does it take 2 weeks time to get a wakalat?
No, we communicated the numbers.
Hmm.
Notice, we communicated to the authority.
When did you communicate? When did you communicate to the authority?
4/6.
4/6.
We received the copy on 3/6, communicated on 4/6.
And still now you have not received wakalat. Or instruction.
Next week, we'll try that.
You have neither received wakalat nor instructions. No wakalat and no instructions.
I'll have it by next week.
62. Mentioned at 10:30, Learned Counsel for the respondent submits that though the respondent had informed the legal department of the BDA about the orders passed by this court issuing notice on him on 4/6/2022, he is yet to receive wakalatnama and or instructions in the matter. He therefore seeks for a week's time to file a statement of objections. Objections, if any, to be filed on or before 21/6/2022, released on 28/6/2022. If objections are not filed by that time, what is the designation of the head of the department? Legal?
Commissioner.
Commissioner irveka illa head of department legal beka? Law officer BDA shall be present before this court. ಯಾವ ಫೈಲ್ ಮಾಡ್ತೀರಾ ಮಿಸ್ಟರ್ ಕೃಷ್ಣ? ದಿಸ್ ಆಲ್ ಡೇಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲೂ ಟೈಮ್ ತಗೊಂಡ್ಕೊಡ್ತೀವಿ. ಇನ್ನ 2 weeks. ಎಷ್ಟು ಸತಿ ಬರ್ಬೇಕು ಹೇಳಿ? ನಾಳೆ ಒಂದ್ಸತಿ, ನಾಳೆದೊಂದ್ಸತಿ, ಆಚೆ ನಾಳೆ ಒಂದ್ಸತಿ, 5 ಸತಿ ಮಾಡಿ. ಶ್ರೀ ಕೆ ಕೃಷ್ಣ seeks for and is granted 2 weeks time finally to file a statement of objection. Objection is intended to be filed on or before 1/7/2022, released on 5/7/2022. It is made clear that no further adjournment will be granted. 47. Yes, Mr. President. Petitioner inform ಮಾಡಿದಿರಾ? Petitioner inform ಮಾಡಿದಿರಾ? Wait.
Page number 8. Page 9, serial number 54 and 65. Page 10, serial number 66 to 71. Number 2. Page number 1, serial number 1 to 5.
Are the pleadings complete? Pleadings are complete. Have you informed the respondents?
Lord's list to serial number 5. I'm appearing for respondent number 3 and 4.
3 and 4. The other councils also, please inform. Without informing, please don't mention.
Page 2, serial number 68. Page 3, serial number 9 to 19. Page 4, serial number 20 to 33.
My lords, I'm for serial number 26, my lords.
Yes.
And for the respondent, my lords, 2 weeks time may be granted, my lords.
Have you informed the petitioners council?
My lords, we will inform, my lords.
Will ಬೇಡ.
Please,
Inform ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಿ.
please, my lord.
Page number 5, serial number 34 to 40. Case number 1, being spoken to serial number 1. There is passing up.
Yes, madam, what are the? Uh, four alone 29 2 ಆಗಿದೆ. Okay. This court ಏನಕ್ಕೆ ಬೇಕು ಮಿಸ್ಟರ್ ಚಂದ್ರಶೇಖರ್? It will have to be respondent. ನಂದೇ ಆಗ್ಬೇಕು. Shri P. Chandrasekhar, Warrant Counsel for the respondent number 3, submit that there are certain typographical errors in the order. Accepting the same, I pass the following order. At para 3, in line 5, after section 29, the numeral 1 in the bracket to be replaced by numeral 2. In para 4, in line 3, same. In para 4, lines, para 4, page 5, line 4, replace word respondent with word court. Page 5, para 4, page 5, line 7, replace word respondent with court. ಇನ್ನೊಂದರಲ್ಲೂ ಹಂಗೆ ಮಾಡಿದೀವಿ ಅನ್ಸುತ್ತೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತಾನೆ ಅದ್ರಲ್ಲೂ ಕರೆಕ್ಷನ್ ಇದೆ.
Page number 1. The advocate for petition number. L should be his third name, my lord. His now name, my lord. That should be NAVAS, my lord. L should be replaced by S.
Now seen.
Yes.
The name of the advocate appearing for the petitioner is corrected from Navaleen to Navaseen, NAVASW.
Yes.
My lord, in serial number 2, I am for the respondent number 2, my lord.
This for the 5th time it's coming up. ಯಾವತ್ತು ಕೋರ್ಟ್ ಫೀ ಯಾವತ್ತು ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೀರಾ? Learned counsel for the petitioner submit that he has paid. 2 ಸತಿ ಏನು ಕಟ್ತೀರಾ ಅಂದ್ರೆ ಪಾರ್ಟ್ ಪೀಸ್ ಮೀಲ್ ಕಟ್ಟಿದ್ದೀರಾ ಅರ್ಧರ್ಧ. ಹಾ, ಸೊ 2 ಸತಿನೂ 100 rupees ಕಟ್ಟಿದ್ದೀರಾ. ಯಾವತ್ತು ಡೇಟ್ ಹೇಳಿ? Submit that he has paid court fee of ₹100 on 6/6/2022 and another time 24/2022 and the first to 24/2022 and 6/6. The registry to verify. And submit a report. There is counsel. Again, objections ಏನಿದೆ? Comply ಮಾಡಿ ಇವಾಗ ಕಾಸು. incomplete index to be corrected. Index correct madilla, page numbering agilla. Counsel for the petitioner seeks for and is granted a week's time to comply with office objection released on 28/6.
Which matter serial number 4?
Yes. Third respondent, I think. The David Krishna Leonard AG accepts notice for respondent number 1. J.C. Kumar is directed to accept notice for respondent number 2. Issue notice to respondent number 3 returnable by 19/7/2022, released on 19/7.
Serial number 5.
David Krishna Leonard AG accepts notice for respondent number 1. The B.S. Karthikeyan Leonard Standing Counsel is directed to accept notice for respondent number 2. Issue notice to respondent number 3 returnable by 19, released on 19.
Serial number 6. Serial number 5.
In part is same, same order as in 4.
Calculation done by the trial court. But the petitioner, Union of India, the defense turbine defense unit, the defense officer acquired the land in 1993. Not for the setting up of gas turbine research unit in Bangalore. But a notification was issued on 1993. But final notification came to be issued on 1994. Special Land Acquisition Officer in 1995 awarded a determined compensation of 1,30,000 per acre. But the respondent land was only 34, extended to 34.
Yes.
But 1999 agreed by the SLO award, the reference was sought a lot, and in the reference, the reference court awarded a award of 4 lakhs per acre. But agreed by that, the respondent challenged that seat before this honorable court. In MFA, the compensation was enhanced from 4 lakhs to 35,70,470.
Yes.
The same was challenged before the Honorable Supreme Court. However, the Supreme Court reduced it. In the High Court, it was taken per square foot as 95 rupees. Whereas in the Supreme Court, it was taken as 76 rupees. It was reduced to 76 rupees,
Increasing what?
development tax from 50% to 60%.
60%.
That is all that is not disputed. But now the dispute is that not finally come to.
The judgment of the Supreme Court is 2011. Now, why are you before this court?
The reason is that not finally come to page 168. An execution is filed before the trial court. After filing of the execution, an amount of rupees 90 lakhs 30,740 rupees is paid as on 25/2000. My lord, is edited at page 172, my lord.
Yes.
the Tara starts from 171. JDR is objection to the memo of calculation and stated that DHR filed execution petition on 8/9/2000 claiming compensation of 79,65,500. They already paid 88,44,000 on 1/5/10/2005. Again on 17/10/2012, they deposited 47,37,095. In all, they have paid rupees 85,81,091 rupees, including interest, apart from the amount of 4,49,649. The total sum of rupees 20 on by 25,000, 90,30,740 rupees was deposited. Now, my lord, an order is passed. Lord, we kindly come to page number 176.
Yes.
In view of the order, claimant would be entitled for statutory interest on additional market value and solution, which the respondent has not calculated. Calculated in the calculation made by the respondent, interest on solution and additional market value is not made. So there is difference in the calculation. But there is a difference in calculation. The reason is that, as per the judgment of this honorable court, the interest should be calculated from the date of interest on solution should be calculated.
Page number.
Please, Lord.
Page number.
The last decision I will be referring to.
ಇದರಲ್ಲಿ ಯಾವ ನಿಮ್ಮ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ MFL ಏನಂತ ಹೇಳಿದ್ರು? We have to go by your judgment, not any other judgment.
But the calculation is that which not we can see. Now, here the calculation on interest on solution is made from the date of acquisition.
What did the MFA court say about it?
Sir, I am not on the point of that. The only thing is that is the calculation part made by the trial court.
Did the MFA court or the apex court speak of the interest in solution?
Please, my lord. Lord, I kindly get it. My lord, you get it at page 130. 113.
13. Yes.
Then the total compensation calculated for square foot is 95 would work out to 35,70,470.
So there is nothing said about the
Nothing
interest.
said about the solution.
What did the LAC court say?
That will not get it at page 18.
Yes.
Reference sent to this court under section 8.
Solution of 30%.
Please, 30%.
Interest of 12%.
30% on enhanced compensation on section 23(2) of the Land Area Act, together with 12% interest on the date of preliminary notification on 16/3/1994. As it was earlier to 11/4/19, that should have been 96, that is 86.
Yes.
The date of taking possession under section 23(1) of the LA Act on enhanced market value. Claimant is entitled to 9% interest for 1 year from 11/4/96, that is taking of possession.
So only the amount of 35,17,000 got replaced instead of 34 lakhs. Rest of it remained the same. So your calculation ಏನು ಮಾಡಿದ್ದಾರೆ?
Calculation is that the respondent filed the execution petition. Execution petition will be getting at page 137. Annexure E.
Yes.
Please, this
Memo of calculation.
please,
Memo of calculation 161.
memo of calculation. But we can see
30% solution ತಗೊಂಡಿದ್ದಾರೆ, 12% ತಗೊಂಡಿದ್ದಾರೆ, 15% ತಗೊಂಡಿದ್ದಾರೆ, 9%. What is wrong with this?
But we can see the interest on solution is again calculated.
If you don't pay it, it has to be paid. Solution goes without interest ಅಂತ your
That
contention.
is not from 1996. The judgment says, Maharaj, it is from the date on 19/9/2001 and supposed to pay interest. If at all I am able to pay the interest, it is from 1999
Mr. Shantibhushan, when did you take possession of the property?
Possession was taken on the 11/4/1996.
So within 1 year, you have to pay.
Please,
Till that 9%, thereafter 15%. Solution is immediate.
please.
You cannot say whenever I pay, I'll pay and I won't pay interest on solution.
I have paid the entire amount. As per this.
When did you pay solution?
The calculation I have paid a lot. I have deposited the entire amount of 90 lakhs.
When did you pay the solution? The dispute is only on solution. Alva? Dispute is only on the interest on solution.
On the interest, on solution.
So when did you pay the solution?
Please. May it take me a lot to calculation, please, my lord.
The long and short of it, there is no other dispute except interest and solution.
Please, my lord. As per the judgment in the Sundar's case, my lord, and Gurpreet Singh case, I am liable to pay interest from 1999-2000. That is the judgment, my lord, I can see.
So what have you calculated? What is it?
All that is that, my lord, the office has to recalculate it, my lord. Now the court will have issued arrest notice to the defense estate officer. My lord, may kindly see page 52, my lord. In the similar circumstance, my lord,
Yes.
may I read it out the operative portion, my lord, at 56, or I will read it out from 55. In Sundar versus Union of India 2001 area SCW, the apex court held that the landowner is entitled for interest on solution. However, in Gurpreet Singh case, the apex court has clarified that interest at 9% on solution is payable, but the landowner are not entitled for interest prior to the date of the judgment of Sundar's case, that is 1990-2001. The apex court has held under. You also clarified that such interest on solution can be claimed only in pending execution and not in post execution. The execution code will be entitled to solve its recovery from the date of judgment.
So 1999-2001.
Please, this is what my stand is that it should be calculated from 1999-2001.
So according to that, what is the amount due?
Please, that the office should calculate.
You can calculate it and tell us.
That as per
If your officers can give all these things, they can do that calculation also. Mr. Shantibhushan.
that I have not tried that.
The right thing for the state to do is, look, there's a miscalculation. That also you haven't pointed out to the execution court.
Please, I pointed out to the execution court.
You said there's a mistake. It has to be recalculated. You calculate the interest, you give it and right royally say, I'm willing to pay this amount.
Please, madam. Please, I do it, madam. I will file one more calculation before the
Afternoon, 2:30. We won't stay the arrest if you don't give that.
Tomorrow. Tomorrow.
You have the arrest ಆಗೋಗ್ಬಿಟ್ರೆ
No.
ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಮಾಡಿ ಮಧ್ಯಾಹ್ನದೊಳಗೆ ಮಾಡಿ
My friend is here. I will not.
You are taking, we are not going to stay anything until you make that submission.
But tomorrow.
We'll have it tomorrow. But if he is arrested, he is arrested. At the request of the additional assistant solicitor general, we will list tomorrow.
Still and not because this matter there is the
15-minute calculation you madak badlo ನೀವು ಹಿಂಗ್ ಕೇಳಿದ್ರೆ ಹೆಂಗೆ? You don't want to spend that 15 minutes.
No, it's not that, my lord. It's not that, my lord. The defense estate officer is not in town. That is the reason, my lord, I thought.
Defense estate officer doesn't do all the calculation. There are so many people. Please get it done.
But till then,
Yes, telling you tomorrow afternoon we'll have it. You don't want it.
please.
Possible.
Great.
And tell us when you will deposit that money also.
Please.
Swami? Despite the order dated 24/5/2022, none appears for the petitioner today also. Process fee and copies have not been furnished, nor are copies furnished to the Learned Standing Council. Hence, petition stands, it appears that the petitioner is not interested in prosecuting the matter. Petition stands dismissed for non-prosecution. Who is R3?
Dispatch on 13/6, yesterday.
When did you pay the process fee? Dispatch ಯಾವಾಗ? 13 ದಿನ ಆಯ್ತು. Counsel for the petitioner submit that he had paid process fee on 31/5. The perusal of the file indicates that the notice has been dispatched on 13/6. Registrar Judicial to inquire as to why it took 13 days for the dispatch of the notice after payment of process fee and file its report. Awaiting service of notice on respondent number 3, relist on next week. I'll barattappa 13th. One week I'll baratta 13/6 dispatch ಆಗಿರೋದು 13/6 ನೋಟಿಸ್ ಡಿಸ್ಪ್ಯಾಚ್ ಆಗಿದೆ. ಎಷ್ಟು ದಿನ ಆಗುತ್ತೆ ವಾಪಸ್ ಬರೋದಕ್ಕೆ? Relist on 5/7. Legible copy of annexure A. You have to produce it. So you sent on 7/6 and you still haven't got any response. How long does the court have to wait, Mr. Chitman? In other matter also the same story. So we'll again direct the presence of and delay like this. The purpose of issuing notice to a standing counsel is that the matter is expedited. Otherwise, we could send it by raised post and wait for 3 months. We have no problem with you. You have discharged your duty, but your client is not. The Ashwin Chikmat, learned counsel for the respondent, submits that though he has informed the law officer of the respondent on 7/6/2022, is yet to receive the wakalatnama and our instructions as also the legible copy of annexure A. He seeks for and is granted 1 week's time finally to do the needful and file objections if any. If objections are not filed before 23/6/2022, objections if any to be filed on or before 23/6, relist on 28/6. If the objections are not filed by that date, the law officer shall remain present personally before this court. You are here. Shri B.L. Sanjeev, it's submitted that Shri B.L. Sanjeev has entered appearance for respondent number 4. Hence, registry is directed to print his name as that appearing for respondent number 4 and delete the name of Shri M.P. Shrikant as that appearing for respondent number 4. Again, copy serve madidira. ಇನ್ನ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡೋದ್ರಲ್ಲೇ ಇದ್ದೀರಲ್ಲ ಮಿಸ್ಟರ್ ಬಿಲಾಲ್. ಸ್ವಲ್ಪ ಸ್ಪೀಡ್ ಅಪ್ ಆಗ್ಬೇಕು, ಸ್ವಲ್ಪ ಅಲ್ಲ ಜಾಸ್ತಿ ಸ್ಪೀಡ್ ಅಪ್ ಆಗ್ಬೇಕು. ವಿಡಿಯೋ ಬರೀ ಅಲ್ಲಿ ಪೊಸಿಷನ್ ತಗೊಳೋದಲ್ಲ, ಇಲ್ಲೂನು you have to file ವಕಾಲತ್, you have to file your objections in time. ನಿಮ್ದು You are the contesting respondent. So Gopal or Beda. Gopal or then objections bad. Choice is was in all matters, objections don't need to be filed. If you want to address arguments, please address arguments instead of adjourning the matter.
We have been allotted the land from the BDM. And construction is going on from 1.5 years. And it is going to be completed in another 6 months. It's a reservoir, long level reservoir.
Coordinated site has to be given by
The BDM. Can be considered, can be disposed of. BDM.
ನಿಮ್ಮ ಇದು ಏನ್ ಮಾಡ್ತಿರೋ ಮಾಡ್ಕೊಳ್ಳಿ ಪಾಪ ಅವ್ರೇನ್ ಮಾಡ್ಬೇಕು KDB ಅಕ್ವೈರ್ ಮಾಡತ್ತೆ BDA ಕೊಡತ್ತೆ BDA ಹೋಗ್ಬಿಟ್ಟು ನೈಸ್ ಕೊಡತ್ತೆ ಇವ್ರಿಗೆ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ BDA ಆಮೇಲೆ ಹೋಗಿ BWSSB ಕೊಡ್ತೀರಾ ಯಾರಿಗಾರು ಒಬ್ಬರು ಕೊಡಿ ಎಷ್ಟು ಜನ ಕೊಡ್ತೀರಾ ಒಂದೇ ಸೈಟ್ ಕೊಡಕ್ಕಾಗತ್ತಾ one site you allotted to 4 people and 3 government and 1 private. What is this? And where should the petitioner go? He is eligible for this site because he has given you possession without contest. So, yav kodtira, elli kodtira, maadi. Neevantu use madidayittu our land. In some matter, we'll have to pass an order until all the disputes of the landowners are sorted out. You are not entitled to use the land anta madbeku. Avaga ella bega agutte. ನಾವು ಯೂಸ್ ಮಾಡೋದು ನಾವು ಮಾಡ್ಕೊಂತೀವಿ ಅವ್ರು ಲಿಟಿಗೇಷನ್ ಮಾಡ್ಕೊಳ್ಳಿ ನಾಟ್ ಎ ರೈಟ್ ಆಟಿಟ್ಯೂಡ್ ಫಾರ್ ದ ಸ್ಟೇಟ್ ಟು ಹ್ಯಾವ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲ ಎಲ್ಲಿ ಕೊಡ್ತೀರಾ ಯಾವ ಕೊಡ್ತೀರಾ ಹೇಳಿ ಇಲ್ಲಾದ್ರೆ ಯು ಸ್ಟಾಪ್ ದ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಯು ಫಾಲೋ ಅಪ್ ವಿತ್ ದೆಮ್ You have better resources to follow with the BDA than the petitioner.
They've allowed me to construct, and now I'm going to complete the entire project.
We should check with them. Have they completed all the process before taking? You are only concerned with taking the land.
They have allotted me the land, and constructed the property. From 2021,
If all the authorities say not my fault, and passing the work madre, elli agutte. Somebody somewhere has to take some responsibility. One of you has to take the responsibility and say, okay, we'll do the needful for the petitioner. ನಂದಲ್ಲ KDB ಮಾಡಿದ್ರು KDB ನಂದಲ್ಲ ನಾನು BDA ಕೊಟ್ಟೆ BDA ನಂದಲ್ಲ ನಾನು ನೈಸ್ ಕೊಟ್ಟೆ ನೈಸ್ ನಂದಲ್ಲ ನಾನು BWSSB ಕೊಟ್ಟೆ BWSSB ನಂಗೆ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಕ್ ಪವರ್ ಇಲ್ಲ Incentive scheme ಏನ್ ಮಾಡ್ತೀರಾ Learned counsel for respond, find some solution and solve these problems. Objections antalla, these are genuine problems. Learned counsel for respond number 3 seeks for and is granted a week agata 1 week alli matte 10 keltara a week's time to file a statement of objection. Objection is need to be filed on or before 23/6, pre-list on 28/6. If any other respondent wants to file objection, they may do so in the similar time frame. Yes, madam. You're producing it now. It's not even stitched, madam. It's loose. You stitch this, otherwise it will not be found after some time. That's what do you want? Password.
Your lordship, is it serial number 13?
Yes.
Your lordship, I am for the society.
So we can take up both, Allah. 23504 has to be decided before. 23504 is pending where now? 27/6. We list on 27/6. We're extending from auctioning and corner side and straight side. Not technical reasons, Mr. Reddy.
He wants the site to be same year. That's his feelings. Not that he has nothing to do with the corner side. Corner side cannot be going anywhere. It's in the rules for moment.
You cannot take advantage of the rules like that to say.
We have to give him a site. There is no doubt about
Then
it.
give him a site here.
Even for alignment of an architect, there is a rule. That's what I'm trying to give you.
You cannot throw up rules.
Yeah.
Then we'll have, as what we told Mr. Sachin, then please first take action against all the people who had formed the sites there.
There is no doubt he's entitled for the site.
Now, have you taken, before you start giving us the rules, then first take action against the people who formed the sites in the buffer zone.
Yes.
You formed sites in the buffer zone. Your engineering wing formed the sites. Your planning wing sanctioned the formation of sites. Then you saw. How is it a mistake?
Therefore, restraining me from auctioning the corner site, he will not able this benefit, number one. Number two, that's the BDA understanding the auction these corner sites, we will not be in a position to develop this very level. Because we are not a profit making organization so far as the distribution of sites to the general public is concerned. We have to make some money only by auctioning these government sites. Then only we can develop this very level. Understanding that's the auction this site. We will not be in a position to provide them electricity facilities, water, sewage, drainage, etc. Therefore, that's what to make it into a layout, which is full-fledged layout. It's a mistake that the government was found. This site was found. There is no other. He is entering for a site, another site, alternative site. But he is definitely not entering for a carbon site, but restraining the carbon from auctioning the carbon site. What benefit will he get? He will not get any benefit. Even if this is kept for 5 years also, but you are ultimately decide the matter tomorrow after the day. He will get that from the another site. Whether he is entered for an alternative site to the CM level or not, you have to decide that. But that also that by restraining me from auctioning the carbon sites only the respect of 1 or 2% to approach it is not about for. Unless and until the auction these sites, this level cannot be developed at all. Kindly see 2 paragraphs in my application, which I have given the details.
Yes, please.
Kindly see my application. Before that, may I request the kindly take the route for a moment.
ನೀವು ಏನ್ ಹೇಳ್ತೀರೋ ಅದ್ ನೋಡಿ. ಯಾವ್ದು ನೋಡ್ಬೇಕು ಯಾವ್ದು ನೋಡ್ಬೇಕು ಹೇಳಿ.
Allotment of disposal of carbon and commercial sites routes. Application.
Yes. Yes.
Auction of carbon and commercial sites. Whenever the authority has found an extension of layout in pursuit of any scheme, the authority may, subject to the general or special orders of the government, dispose of any or all the carbon sites or commercial sites in such extension are layout by auction in accordance with these rules. Due publicity shall be given in respect to the carbon sites or commercial sites by auction. Specify the location, number, etc. Highest bid amount of the deposit and such a particulars of the commission and consider necessary by fixing the amount, etc. This is the procedure.
Subject to general or special orders of the government.
Orders of the government.
So ಏನಿದೆ ಆರ್ಡರ್ಸ್ ಹೇಳಿ.
That is with regard to reservation, etc. Reservation can be made in respect of.
Yeah, we'll ask the state what they have to say about it.
Reservation. This is the subject of reservation of carbon sites or commercial sites.
Hmm.
The authority may reserve carbon sites or commercial sites in any area for allotment to any specified purpose to which an institution, body or corporation that is without transport, but such rates as the authority may decide.
Yes.
Now, where the carbon site or commercial sites are reserved under subgroup 1, the procedure to be followed for allotment of these sites shall subject to general and special orders of the government by be determined by the authority. Therefore, that's the government will specify with regard to the manner, supposing that it is the result for the 10% for the disabled, 15% of the CST, etc. Those can be the special orders, special orders that will be part of the government.
Yes.
So, this is rule 11A. 11 capital A of the allotment books. Of the allotment. Allotment rules of 1980.
Yes. Yes, yes. Good.
Allotment of alternative sites. Where the authority is unable to hand over possession of the site allotted under these rules. Of course, that it's under these rules. Allotment is made under these rules only. To any authority, due to share of the court or for any other reason, authority may allot an alternative site to such allotment, subject to the following conditions. An alternative site to be allotted only when the mission was on the part of the authority of making the allotment of sites. Or the possession of the site, so allotted working is not given to the allotted to the share of the court or to any other school. Subject to government, the authority of sites, alternative sites to the allotted to the authority, the same sites are originally allotted. Or in the layouts formed by the authority subsequent to the formation of the layout, in which the sites were originally allotted. 3. Alternative sites shall not be allotted to layouts formed prior to the layout in which sites were originally allotted. Even if sites are physically available in the layout formed prior to the layout, in which original allotment was made. So, allotting alternative sites bigger in dimension than the sites originally allotted shall not be considered for allotment. However, an alternative site of 10% over and above the area for the original allotted site may be allotted, and in such cases for the extra cycle area involved, the additional cycle will be applicable to the layout for that site that is allotted. So we are in addition to the difference in cycle that is allotted. Provided that the extension time is allotted. Therefore, that's the rule itself says that for mistake, if something has happened and they are unable to do the site, certain issue, maybe we have to do some alternative site, same level, or in the layout subsequently followed. This level will not go to the level, it is there, which is subsequently followed than the alpha of the layout. Now, the workshops are there, that's alpha of the layout was stood right for you. We have been lower an extent of about 1,000 acres for mutually modified. But layout has been, we are going to farm the layout only in about 400 acres of land. And that too, that's the known because this is under the special state
Yes.
Now, this is the question. This site which we have identified now, site is the mitigation site is very good layout, number one. Under these rules, therefore, the constructors of these two rules, that's directive actions. To make it clear that he is entitled for an alternative site and not a corner site.
Where does it say not a corner site?
Not a corner site, because corner site
By way of
it has to be disposed of only by public auction. Therefore, that's by preventing me from disposing of the corner sites, he will not continue to benefit of this improvement, will not continue to benefit of the petitioner in any manner. Other than that's preventing BDA from developing this very layout, unless and until this corner sites are auctioned because about 700, 800 in number. I asked them, they say that about 800 sites are there, not covered in layout. Now, unless and until we dispose of, currently see my application, the details as to how many sites currently see my application, page 11. Page 11, stated from late onwards. For project purposes, last
Yes.
I further state that as donate DTIs farm there to the extent of 459 acres only, which are free from litigation. Due to the pandemic litigation and due to the allotment of development plots at 40/60 ratio, this is what happened over housing here for a moment. After this is done, in Botolam's on the state, after the plots were allotted, Botolam's on the state, the upper sports and governments are entitled for 40/60. Therefore, sites which were allotted also, we had to cancel the allotments and give to the owners of the land that opted for 40/60.
Yes.
Once they have opted, all these persons go to the earlier allotted sites. And now we become basically because we have planning from taken because the sites are percent before 40/60. Now kindly see. We recently cleared about 450. Now kindly go to paragraph the tabular column of page 1. We have found these many sites and distributed into allotment in order to protect our layout to these persons who are displaced from the authority. Now I state that the BDS identified litigation free corner sites in authority layout and proceeded to auction the corner sites in order to raise funds to develop the lands in authority layout like civil, electrical work, water supply, the costing which is 234,000 for civil work, 245 crores for electrical work, including electrical substation, 386 crores for water supply and sewage works. As much BDS therefore, this much money is required to develop this layout. Unless and until the sites are auctioned and this money is raised, you will not be in a position to develop this account layout itself. Therefore, that this will in any case not include the benefit of the sites and identify the vegetation the site. If my allotment fund is not willing to accept it or not, I can consider hearing the matter. If he is entitled for a site, either in this layout itself or in any other layout. That is all. But he is definitely not entitled for a corner sites.
Mr. Krishna, you seem to be the only person who can rescue everybody. because it is your notification, by virtue of which they are constrained to sell it by the corner sites. Now, admittedly, there are some 700 sites which are available, 800 sites which are available as corner and stray sites included.
The value of the site plots will be, if we put it to auction today, we go and get somewhere and don't get about 10,000, 11,000 rupees, they purchase an auction. And it is not, that's the augment their revenue by disposing of this site by a corner site. This amount of about nearly 800 crores will be referred for developing this layout. We will not be in a position to write because we are allotting the other sites without any profit. Whatever is the development work, we divide it and allot it to the general public those who are a leader. And to develop it, unless and until you dispose of the corner site, we will not be in a position to develop the layout at all. That is the ticket situation in which we are placed.
What would the government stand be in this kind of a situation? We'll make you a part.
The government of the country for the art project. Circular issue. We have one state around the application. Document number 2.
No, we want to know the stand on the allotment mode where whoever is willing, that's a different issue. If they are not willing and they want it within this and they've been waiting for so many decades. 16, huh? Yes. This is as regard that 60-40. Document number 2.
Document 1 of 3 yesterday.
1, huh?
Sorry.
Yes, yes.
Arakavati Parayana and Innovation Authority, Arakavati Parayana Innovation Authority, Kashasati, Narapasu Subject Parayana and State and Maru Budget, other Sanka so. Therefore, the check is on the but the Prasavan and Sarkava, the Parasa, the Sunday, issue so payable and Sinai, Arakavati Parayana and Innovation Authority, other Parayana. ಕಾನೂನು ಕೊಡಗಿನಿಂದ ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡಲು ಸಾಧ್ಯವಾದ ಕಾರಣ ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಬಡಾವಣೆಯಲ್ಲಿ ಬದಲಿ ನಿವೇಶನ ಸರ್ಕಾರದ ಅನುಮೋದನೆ ನೀಡಲು ತಮ್ಮ ತಿಳಿಸುವ ನಿರ್ದೇಶಿಸಲಾಗಿದೆ. The reason why we are not able to accommodate all these people in that says, one is this Part 60 scheme has come after the formation of the law. 2 is the modified sanction plan. The elections have observed in the elections order that buffer zone area, etc. And now we have been able to form only in the extent of about 455 acres. And we have accomplished all the land owners who have opted for 40-60 scheme. That is when the correspondence has gone between the authority and the government. When government finally said that you can accommodate all these people in Nagaland. Therefore, we have identified so far as the cleaners are concerned, the litigation free identified sites in Nagaland. They can come and inspect and we will file a memo before the Honorable Court saying that this way, this side, this side, this side, they are giving it to them. Let them go to verify. They have already said. Therefore, we will expect. Preventing me, you will not get anything.
Always down time of your water passing the order, which we call the person who this is 2006 allotment. From 2006, alternative allotment was made which structured in the same. Now, my lord, the ministry of course points to 11A and the one side too. My lord, the simple fact remains there is a violation of Article 308. It is, my lord, without any due process, my land is obliterated. By their own admission, they say there are sites, whether they are corner sites or other sites, or we're not concerned. There are sites. As per Rule 11A, priority must be given to an alternate allotment in that same site. The notice of allotting it, whether it's a corner site or whether it's a site elsewhere, of course the rules will vary. But what we're saying is, if there are alternate sites in that same plot, please identify.
What do you say about the difference in the costing?
we say, ultimately someone has to be held accountable.
Yeah, accountability is one. The difference in costing, what do you?
I can seek instructions as to whether the petitioners will bear the difference in cost to some degree. Between the price paid here and
Attached to the auction, how much ever, whoever you are,
Well,
also
of course,
are not participating.
the project has to equity under 226. No ruling can prevent your lordship from exercising that power. That is my
Okay,
expectation.
Krishna, I think the state's position will have to be required here. The state's position in this kind of, because BDA is saying if we don't get the money, we won't be able to form the layout. Because of that, so many people who have been allotted sites are left with no sites. And you instructions ತಗೊಳ್ಳಿ, instructions ತಗೊಂಡು no, the state cannot be sitting on the basis of.
I may take your lordship into confidence and say, I'm told that in fact I had a word with the commissioner this morning. Many of the people, most of the people who were allotted sites and who have not now been allotted alternative sites in Narakotam, because it's a big increase very good there. People are voluntarily asking for Narakotam sites. And because it is very beautiful there and told. So I have not seen that there. People are, in fact, they are saying, some of them who have been allotted sites in Kavati layout, that is before they come to.
No, that is a choice that they have to exercise in study. We cannot force anybody to exercise the choice. It is their choice whether they want.
There is a law which I have brought to your lordship's notice. Government sites can be disposed of unless and until the rule is amended, or your lordship says that you have to do it.
That this court has done in 3-4 matters already. It's already done. We'll take it off for final disposal. That is the thing, and we'll take it off for final disposal. We'll make the state a party.
Yes.
And next week we'll post it for final disposal. In 1 week we'll hear it on next Tuesday and dispose of the matter. We'll hear the matter on next Tuesday and dispose the matter if that is the one which is coming in. We will sit late if required and we'll dispose of the matter on that day. Let us have the state's opinion also. Stand. The submission of Sri Nanjan Reddy, letter senior counsel, is that in terms of 1 week, let us get the stand also. No, not 2-3 people only, all the other people also. There are so many people who are, there are so many petitions which are coming before this court on this. ಎಷ್ಟು ಮ್ಯಾಟ್ರಲ್ಲಿ ನಾವು we have been referring. ನೀವು ಲಿಸ್ಟ್ ಮಾಡ್ಕೊಡಿ ಎಷ್ಟು ಆಲ್ಟರ್ನೇಟ್ ಸೈಟ್ಸ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಅಲಾಟ್ಮೆಂಟ್, ಆವಾಗ ನಿಮ್ಗೆ ಗೊತ್ತಾಗತ್ತೆ. ಇದು ಮೂರೇ ಅಂತ ನೀವು ಇದ್ರಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಬರೀ 3 ಅನ್ಸುತ್ತೆ. ಕೋರ್ಟ್ ಮುಂದೆ ಬರ್ತಾ ಇರೋದು there are hundreds. That is the problem. Because all those people are made to run helter-skelter because of BDA not discharging its obligations. We're not saying this commissioner, that commissioner, or this officer, that officer. Whoever, it's happened. It's a legacy issue. The legacy issue needs to be sorted out so that this problem needs to be closed. ಇಲ್ಲಾದ್ರೆ ಅರ್ಕಾವತಿ ಇನ್ನೊಂದು 50 ವರ್ಷ ಇನ್ನ ಇಟ್ಕೊಂಡಿರ್ತೀವಿ. ಅದು ಬೇಡ ಅಂತ. Let us bring a closure to this. Let people are now in their, when they applied, they were in their 50s. Now they are in their 70s and 80s. ಇವಾಗ ಅಲ್ಲಿ ಹೋಗಿ ಇಲ್ಲಿ ಹೋಗಿ ಅಂತ ಏನೋ ಒಂದು ಸೊಲ್ಯೂಷನ್ ಲೆಟ್ ಅಸ್ ಫೈಂಡ್ ಔಟ್.
I know, but ಇದು ಈ litigation ಒಂದು ಫೈಲ್ preliminary notification ಆದ್ಮೇಲೆ ಒಂದು litigation ಬರುತ್ತೆ. Final, of course, I am not defending the development because my officers also will be involved with many of these landowners, etc., many of these land developers. But ultimately, sufferers are the site allottees. I understand that.
We have paid money. The money has been with you.
Some of these things, perhaps you cannot do it.
In this case, though, you executed a sale deed also. I mean, unilaterally, and no action has been taken against your officers.
That is why the rule says, if for mistake, for some mistake or any other mistake of the authority, or otherwise, alternative site is required to the same level or in another level.
Mistake is a very small word, Mr. Reddy. Mistake is a very small word. Illi sites have been formed in a buffer zone. If it was a private developer, you would have initiated proceedings under section 192. Nothing has happened here. ನೀವು ಹೋಗ್ಬಿಟ್ಟು ಓಕೆ ಮಿಸ್ಟೇಕ್ ಆಗೋಯ್ತು ಅಂತ ಎಲ್ಲ ಕ್ಲೀನ್ ಮಾಡಿಬಿಟ್ರೆ JCB ತಗೊಂಡೋಗಿ ಒಂದು ರೋಡ್ ಮಾಡಿಬಿಟ್ಟು ಆಯ್ತು ಇವ್ರು ಹೋಗಿ ಕೆಂಪೇಗೌಡ ಲೇಔಟ್ಗೆ ನಾವು ಇಲ್ಲಿ ಕೊಡಲ್ಲ ಅಂತ. That is not the way that BDA can function. Anyway, let us see if the state will come to your rescue. Next Tuesday. All BDA matters are on Tuesday, next Tuesday. The submission of Shri Nandan Reddy, Learned Senior Counsel, on behalf of the BDA is that in terms of Rule 3 of the BDA bracket disposal of corner site rules 1984, the BDA is under obligation as per the directions of the state government to dispose of corner sites, intermediate sites, commercial sites, and other auctionable sites only by way of an auction and not otherwise. He refers to Rule 4, which speaks of reservation, Rule 4 of the said rules, which speaks of reservation of the rules, and Rule 5 relating to allotment of corner sites. Apart therefrom, he refers to Rule 11 of the 11A of the BDA allotment of site rules 1984 and submits that in the event of a site already allotted to an allottee not being capable of being transferred due to any order of the court or due to a mistake on part of the BDA, an alternate site could be allotted to such allottee. He submits that Rule 11A does not envisage allotment of a corner site or a stray site as an alternative site, and therefore he states that the order which is being passed by this court staying the BDA from auctioning the corner sites and or stray sites will not inure to the benefit of the petitioner. The perusal of Rule 3 of the rules would indicate that the auction of corner sites, intermediate sites, commercial sites, and other auctionable sites is as per the general or special orders of the government or the state government. Thus, I am in the considered opinion that it would be required for this state to get the opinion of the state in regard to the frequent situation that has arisen in the present matter, inasmuch as BDA contending that without auctioning the corner sites, they would not be able to develop the layout. And on the other hand, the interest of the petitioner also needs to be protected, who has been allotted a site which could not be handed over to him, which was handed over to the petitioners, but had to be cancelled on account of the BDA. Officers of the BDA have informed the sites in the buffer zone of a nala, requiring the allotment of an alternate site. Correct. The state of Karnataka, represented by the Chief Secretary in Urban Development, by Secretary Urban Development Department, is brought on record as respondent number 2 Shri B.V. Krishna, learned AGA, accepts notice for respondent number 2. He seeks for and is granted a week's time to obtain instructions and make his submissions, preferably in writing by way of an affidavit of the said secretary. Learned counsel for the petitioner to carry out necessary amendment and file amended cost title, has also furnished a copy of the writ petition along with annexures, as also statement of objections and or applications filed by any and all other respondents in the present matter to Shri B.V. Krishna by end of the day today. Relist on 21/6 at 2:30 p.m. Yes, for final hearing. 2:30 and the specific in that one, so that all your appraisals are covered by that. Connect ಮಾಡದ 55 in first list, registered to connect Shri Lakshmi Rao Leonard Council submit that WP number so and so at sale number 55 and WP number so and so at sale number 28 of the second list are connected with the above matter. Registry to connect the same and relist on so. Mr. Sachin, idena itu registration. We have asked BDA to register their department. Mr. Sachin was taken the obligation. ಕೊಟ್ಟಿದ್ದೀರಾ?
Where in that time the direction towards the DPA, they have to file their objections to the INF.
The lead is ordering DPA to restrain the DPA from creating third party interest.
So which IA do you want to argue, Mr. Goda? IA1 first argument ಮಾಡಿ IA1 of 2020 ಆಮೇಲೆ IA1 of 2021 ಬರೋಣ. Yes, so what is your submission on that?
By the BDA in favor of the petitioners who are actually ineligible candidates. As per the site department rules, 10B, only one person per family is entitled to seek the benefit of site allotment. However, the petitioner for the court.
Incentive scheme. Is it an incentive scheme?
No, on the basis of all affidavits have taken benefit of having sites registered in 3 names from the same family, mother, son, and daughter-in-law. I, as imperial applicant, was
IA1 of 20, just one moment. We are looking for your application. IA1 of 2020. When was it filed?
Filed on 16th March 2020.
Yes. So you are.
I was the original complainant before the BDA authority who brought to their notice the illegal allowance. On the basis of my complaint, which I have annexed in A&B, inquiry was conducted and report was given saying that these allotments are illegal in nature. And thereafter, their allotments were cancelled. That's the very reason they have come before the court. I represent the original complainant who was the whistleblower in the matter. I may not be a necessary party, but I am certainly a proper party because the reason being that there are certain factual aspects to this matter which neither of the parties have brought before the court.
Why do you want that?
The main petition, the BT is still not filed their objections.
As regard the main petition,
Yes, yes.
they have filed objections. As regard the main petition, they have filed objections. They have filed their objection on 16/8. Yes. What is your objection?
I have filed a no on 6/7/2021. But this today, what happened was this teacher was unauthorized occupation of the website. Considering their unauthorized occupation, in fact, during the occupation, they were taking to oppose December 4th, and that unless the application for legalization is considered going disposition. Based on that, they were allotted with objections. This is site number 1 and 1E. In the RPS number of 2020. Independently, allotment and execution of civil in the year 2009. Independent of this product, they had made an application in the BT for allotment of sites under BT allotment. That sites were allotted in the year 2002. 2002.
No, that is on the merit. What is your objection to them coming on?
Therefore, the petition is that you have got allotted the second, second sites in the second time. In 2009, therefore, there is violation of allotment. That is the main and she is the complainant as it was, she is the my objection, my lord, is that we are requesting my lord to take.
She is not the complainant. He is the complainant. She is representing him. Don't make it personal. Like,
my objection, my lord, is in judgment. We have put it along with the memo, the 6/7/2021.
Here. Sarah? Yes.
But that appears to be a desirable consequence of the rule, rather than the meaning of it. The person to be joined must be one who is necessary as a party. What makes a person a necessary party is not merely that he has relevant evidence to give on some of the questions involved. That would only make him a necessary witness. It is not merely that he is an interest, he has an interest in the correct solution of some questions involved, and as part of relevant arguments or not. The only reason it makes it necessary to make a person a party to an action is so that he should be bound by the result of the action, and the question to be settled. Therefore, there must be a question in the action which cannot be effectively and completely settled unless there is a party. The line has been drawn on the violent construction of the road between the direct interest or the legal interest and commercial interest. It is therefore necessary that the person must be directly or legally interested in the action in the answer. We can say that the implication will lead to a result which will affect him legally, that is, by maintaining his legal rights. It is difficult to say that the rule contemplates joining as a defendant a person whose only object is to prosecute his own cause of action. Similar provision was considered in so way after quoting the observations of so that they do test lies not so much in analysis of what are the consequences of the applicant's rights, but rather in what will be the result of the subject matter of action, if those rights to be established. So, this aspect not came up for consideration before the Court of Commerce. So, what you think in cases of BDM, there will be a complaint alleging violation of building bylaws and construction by the landowner. Because there, the matter came up for consideration and resolved report got in the district, which is respective 2017. That is a case 12 of the list of judgment. And after considering all this, it takes note the complaint in case of where we have got a complaint in case of BJP is not a necessary party. The principles are enunciated at internal take 17 of the judgment. And at para 28, 28 is distributed another case.
Then what do you want to say by relying on para 29? Nothing is there in that.
Para 22. Summarize.
Yes.
And subsequently, the diverging decisions are analyzed. And ultimately, at para 38, it's another.
It was a matter before the tribunal.
This was a matter before the Karnataka tribunal, where a complainant had made an application.
Challenging the 321 notification. Challenging 321 notification notice. Here we are under 226.
Again, that came out of consideration whether it can be permitted to conduct proceedings before the tribunal. Ultimately, what was considered was only a reason to complain.
Tribunal's jurisdiction is limited, Mr. Bhatt. In that limited jurisdiction, the court has considered that and said the jurisdiction being limited, it cannot be enlarged and they'll have a different cause of action.
Whether he can be included in the tribunal or not. What was considered whether he can be included in the facts of the case.
That is why it said tribunal was rightly rejected the application in terms of regulation 40A of the regulations applicable. Yes.
It would make the petitioner merely a witness in the case. It would not make the petitioner a necessary party. Moreover, merely because the petitioner may want some duties to cover the case of respondent number 3, which aim would not make the petitioner a necessary or proper party to the case. Furthermore, the order of either in favor of respondent number 1 or against that is not binding on the petitioner. Further, the petitioner may use that the alleged illegal petitioner likely to affect his right, namely the illegal construction may not listen or may adversely affect the petitioner's right to hear and right. But such each of these rights gives rise to another and different cause of action in favor of the petitioner. The petitioner cannot be permitted to amalgamate these cause of action in present case while with the respondent number 1 is the action of the respondent number 2. There are different petitioner. Whether any order is being passed from this order, whether it is going to adversely affect the rights of the petitioner. The answer is no more, it is not a necessary or a proper.
Yes.
So the PDS
Orders on. What do you have to say about the application? Charity, what do you say about including up?
Well, 2 or 3 submissions in this matter. Point number 1, a criminal proceeding has also been initiated by the FIR comes is registered for CH-21. This very fact has not been brought before your lordship's notice up until this time. I, as impleading applicant, I am bringing certain records to this honorable court's notice, which will help this honorable court in making correct assessment of the matrimony order. Secondly, minutes, the fact that false evidence were filed in this matter. Kindly, the lordship's notice, page 50 minutes of my application. 50.
Yes.
This is for Karnataka, page 50, paragraph 2 minutes. This is the petitioner's affidavit for the authority to cite the law. Renewal of the Liberty Private Activity, Nanagati Atman Nanda, or entity, Atman Nanda, Avalanche Makadari, Yaudi negation, Mare Mari, Continue Villa, Habu, Nanagati Nanda, entity Nanda, and Avalanche Makadari. Renewal of the Liberty Private Activity, he in there. Renewal of the Liberty Private ಅಥವಾ ಬೇರೆ ಯಾವುದೇ ಕಾರ್ಯಕ್ರಮ ಪುನರ್ನಿರ್ಮಾಣ ಸಂಘ ಮಂಡಳಿಗಳಿಗಾಗಲಿ ಮನೆ ಅಥವಾ ನಿವೇಶನ ಮಂಜೂರಾಗಿದೆ ಎಂದು ಈ ಮೂಲಕ ಪ್ರಮಾಣ ಪೂರ್ವಕವಾಗಿ ದೃಢೀಕರಿಸುತ್ತೇನೆ. 2A ನಾನಾಗಲಿ ಅಥವಾ ನನ್ನ ಕುಟುಂಬದ ಇತರೆ ಅವಲಂಬಿತ ಸದಸ್ಯರಾಗಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯದ ಅಥವಾ ದೇಶದ ಉಳಿದ ಭಾಗದಲ್ಲಿ ರಿಯಾಯಿತಿ ದರದಲ್ಲಿ ಯಾವುದೇ ನಿವೇಶನ ಮಂಜೂರಾಗಿ ಆಗಿರುವುದಿಲ್ಲವೆಂದು ದೃಢೀಕರಿಸುತ್ತೇನೆ. This affidavit was dated 11/8/2009. And this comes later to the other side allotments which have already been made in the names of the members.
No, that's on merits, on impleading application. Only on impleading, we'll come to merits later. First you come on record or.
Which the authority, council appearing for the authority should have brought before this court has not come on record. In this slide, I am stating that being a proper party, my assistance will help this honorable court to educate the matter.
You better address the allegation against you.
But I have no participation. Only you face to be, but I can remove the participation. I have no interest in the application of somebody else gets the fact. I do have to do what I have to act in accordance with and not have taken action in accordance with which I have placed this document for your option to show that how the petitioner is not entitled to the release as in this part and how I should justify the action which I have taken. But I have come clean before. In spite of it, if any other documents which are not in the knowledge of media, bring it to the knowledge of the competition, but they can very well do it. But ultimately, but I have no objection for them to come in, but let it not be on my board.
FIR is filed by?
Filed by the BDA against the petitioners.
Have you produced that FIR?
That is on the ground. I am justifying my cancellation order here. And on the
Based
ground.
on the very inquiry report, the inquiry which was conducted on the complaint that I did for the authority.
I have
It's not a small motor case. In fact, I said along with my learned counsel.
You have to. The only person that you can say that on this.
Four sites were in the name of the same family.
So Gauda, the jurisprudence on this is being changing now. The jurisprudence on this has changed. Earlier, this one was the complainant can only file the complaint, bring it to the notice of the concerned authority. Authority will take action on it. Complaint is out of the picture. That was under the presumption that the authority will do its job in the required manner. Now, over the last couple of decades, the whole situation has changed. The complainant is permitted to assist the public prosecutor in a criminal proceedings. Now, the complainant is permitted to assist even opposing the bail. Things have changed. So let them come on with it. Whatever is that, don't fight shy of it. Answer those questions. IA number 1 of 2020 has been filed by the original complainant seeking to implead himself as a party respondent on the ground that the impeding applicant was the one who had brought a notice of the BDA about the about the violation of the applicable laws committed by the petitioner while obtaining allotment of sites. And it is only in pursuit of the said complaint that action was initiated against the petitioner. The very said action having been questioned in these proceedings, it is contended that the impeding applicant would be in a position to assist this court to place the necessary documents on record to ascertain the veracity of claims made by the petitioner or otherwise. She submits that it is in pursuance of the actions taken by the impeding applicant, complaints filed by the impeding applicant that the action has been taken against the petitioner, and as such the impeding applicant is a necessary party to these proceedings. Shri Sharad Gowda, learned counsel appearing for the petitioner, would however object to the same, contending that there is no right vested with the impeding applicant to participate in these proceedings. Any order passed by this court would not in any manner adversely affect the rights of the impeding applicant. And without such a finding being given, a person cannot be brought on record as a party respondent. And in this regard, he relies upon the decision of the apex court in Ramesh Irachand Kundanmal was Municipal Corporation of Greater Bombay and others, 1992 2 SCC 524, more particularly para 14 thereof, which is reproduced hereunder for easy reference. He also relies upon the decision of this court in WP number 14690 of 2017, dated 31/5/2017, more particularly para 35 to 38 thereof, which are reproduced hereunder for easy reference. Relying on the above, he submits that merely because the impeding applicant would have some evidence to give or some questions involved in the case would not make such person eligible to be made as a party respondent. He can at the most be a witness in the proceedings. He further submits that this court in Srinivas Pungavi's case has categorically held that any grievance that the impeding applicant may have cannot be amalgamated with the causes of action in the appeal to bring them on as a party respondent. On these grounds, he submits that the application is required to be dismissed. Shri M.V. Charity, learned counsel appearing for the BDA, submits that insofar as the BDA is concerned, the BDA does not require the support of the complainant. The BDA would discharge its statutory obligations in accordance with law without requiring any help or assistance from the complainant. But however, he further submits that he has no objection He submits that he would leave it to the discretion of the court whether to allow the application or not. He submits that he neither opposes, and thus his submission is that he neither opposes nor supports the impeding application. That I heard so and so various places. The petitioner is before this court challenging the orders passed by respondent number 2 BDA in cancelling the allotment made to the petitioner of the sites by respondent number 2. A perusal of the impeding application as well, petition, the documents along with the petition, the impeding application, the documents along with the impeding application would indicate that it is on account of the complaint which had been filed by the impeding applicant that the action was initiated by the BDA. Until the said facts were brought to the notice of the BDA, no action had been initiated by the BDA. At this stage, it is premature to say whether the BDA would have initiated action or not, but suffice it to say that in the present case, it is only after impeding applicant brought to the notice of the BDA and filed a complaint that the BDA had initiated action. Thus, if not for the said complaint of the impeding applicant, no action would have been taken against the petitioner. The decision of the apex court in Kundanmal's case was one relating to a suit where an application order 1 Rule 10 a suit for injunction restraining the municipal corporation from demolishing the structures where an application had been filed. The Honorable Apex Court coming to a conclusion that the cause of action of the impeding applicant was different from that of the plaintiff, and taking into consideration that the plaintiff could file a separate suit, the impeding applicant could file a separate suit, dismiss the said application. In view thereof, I am of the opinion the said decision would not apply to the present facts. As regards Srinivas Kongavi's case, that was a decision relating to an impeding application filed before the Karnataka Appellate Tribunal, wherein a challenge was made to proceedings under 321(3) initiated by the municipal authorities against the appellant therein. In the said proceedings, the impeding applicant wanted to be brought on record, since it was on his complaint that the proceedings under Section 321 of the Municipal Corporation Act was initiated. This court, after considering the matter, was of the opinion that in terms of Regulation 40A of the Karnataka Appellate Regulation 1979, the cause of action would be only the cause of action for the appellant was the issuance of the notice under Section 321(3), and it is only that aspect which will be considered by the Karnataka Appellate Tribunal. And the impeding applicant wanting to come on record to place certain evidence on record, the said evidence could be placed on record as a witness in the appeal. In the present case, there is no evidence which would be required to be made. This court would be deciding the matter on the basis of the affidavits which have been filed and the documents which have been produced. Such being the case, I am of the considered opinion that the decision in Srinivas Kongavi's case would also not be applicable to the present case. In view thereof, IA-1 of 2020 is allowed. The impeding applicant is brought on record as respondent number 3, counsel for the petitioner to carry out necessary amendment and file amended cost statute. 2 weeks' time is granted to the impeding applicant to file to the respondent, newly inducted respondent number 3, to file the statement of objections along with documents, if any, which shall be filed on or before 30/6/2022 after serving a copy thereof on the counsel for the petitioner and the other respondents, released on 5/7. Until hearing, we should not allot it to anybody, Mr. Director. Until this matter is disposed, don't allot it to anybody. Respondent number 2, BDA, He is restrained from allotting the sites in question to any other third party until the next day.
Serial number 16.
Counsel for the respondent submit that the statement of objection is ready and we filed during the course of the day today. In the course of the day tomorrow. Released on 21/6. Although usually, Mr. Basraj, we can dispense with certified copy of annexure A, accepting the reasons stated in support of IA 1 of 2020, production of certified copy of annexure A is dispensed with. IA 1 of 2020 is allowed. 17. Yes. IA copy ಇವತ್ತು ಯಾವ direction na? You are arguing on the main or on the IA 1? ಬೇಡ ಇವತ್ತು ಬಂದಿದೆ ಅಂದ್ರೆ ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತದೆ. ಯಾವಾಗ ಆಗ್ತದೆ? Shri Lakshmi Rao, the counsel submit that he has received copy of IA 1 of 2022 today. He seeks to and is granted a week's time to file his objections to said IA. What about main? Main hakila. Objection is said IA and main. Objections, if any, to be filed on or before 24/6/2022, released on 28/6/2022. Accepting the reasons stated in support of IA 1 of 2021, dispensation of the original of annexure H is dispensed with. IA 1 of 21 is allowed.
Serial number 18.
Who is R6, R8 to 11?
First one yesterday, 13/6.
Process fee have put to the Mr. Evaluation.
Taken twice your lodge, not when it comes. I will serve upon them. My lodge only, my impediment is now because when rights were acquired, government has acquired land, even to the society formed a layout in the permission of Bangalore Development Party. And subsequently by 2020, after the allotment of the site, layout plan has been modified to them. If my sites are now, they have deleted my sites and allotted to the lots now. Only at the behest of the seventh respondent, arranged the lots.
When did you pay the process fee?
Process fee was paid, you have to pay kindly, the process fee was paid immediately or as of on the date now. Last application notice was served upon the government.
30th December 2021.
30th December 21. The notice was issued on 23/5, no order agile. 30th December agile.
Is there a process?
Process has been waited on.
But dispatched on 36.
Dispatched to the office also.
ಅದು ನೋಟ್ ಹಾಕ್ತಾರೆ ಏನೋ ಪೋಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ.
Process fee was paid on 30th December.
20th December.
When the counsel for the petitioner submit that he has made payment of the process fee on 20th December, which is on 23/5, notice 2022 notice was ordered. On 25/1/2022 notice was ordered. As per the note put up by the office, by the registry, notice is stated to have been dispatched only on 13/6/2022. Registrar Judicial is directed to inquire into the matter and submit his report as to why Why there is such a long delay in dispatching of the notice to the respondents? Who are these respondents, Mr. Ravi Shankar? 6, 8 to 11.
Society, because like the document, he comes, like not. That's a major because he made a party.
Are you seeking any relief against them?
No, there is no release fund like an exam. What is the release fund is against the Bangalore Development Authority? Any respondents number?
ಇಲ್ಲ ಕೇಳಿದ್ದೀರಲ್ಲ ಅದಕ್ಕೆ ನೋಟಿಸ್ ಹೋಗಿಲ್ಲ. Prayer 4.
8, 9 and 10 because what happened now the construction.
ಅವ್ರು ಬರ್ದೇ ಇರಲಿ, we can't consider it.
Please, I do understand. Process has been paid, not the office on dispatch now. I am being disappointed. See, now
That is why we are asking for.
They
They
will
list
give
on-
it on the lot.
ಅವ್ರಿಗೂ ಟೈಮ್ ಕೊಡ್ಬೇಕು ಅಂತ we list on 21/6. Counsel for the petitioner seeks and is granted. 10 days time to file with rejoinder. Rejoinder if any to be filed on or before 23/6. After serving a copy thereof on the counsel for the respondent, released on 28/6. IF2. You also want to file. Sri V. Krishna, learned AG, also seeks for 10 days time to file a statement. Seeks for 2 weeks time to file a statement of objection. Objection statement, if any, to be filed on or before 30/6/2022, released on 5/7.
Appear for the respondent, Your Lordship.
You file your objection, Mr. Karan, ready?
Yes, Your Lordship. Ready, Your Lordship.
Ask over, Uncle.
My children.
Yaru, you are appearing? 2 and 3 you are appearing. Registry is direct to delete the name of Sri B.S. Sachin as entered appearance for R2 and R3. Registry is directed to show his name as that appearing for R2 and 3 and delete the name of Sri Keshav R. Agnihotri as that appearing for R2 and 3. Yes. 69 ಬಂದಾಗ ಅದೇ ಹೇಳಿ. Mr. Counsel, please wear your band properly. That is not the way to wear your band.
An officer to be present in this case, and also specific direction was given to the council to send objection. Both have not been checked, and they have come with some reason when this they not heard in the last petition or subsequently it's not also not but the special direction was given to the law officer to give the latest report and to be present before the street.
ಆಯ್ತು, ಅದನ್ನೇ ರಿಪೀಟ್ ಮಾಡ್ತಾರೆ. ಅವ್ರಿಗೂ ಹೇಳೋದು ಬಿಡಿ, ನೀವು ಹೇಳಿದ್ರೆ. ಇಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಕೇಳಿ ಬೇಡ. ಎಷ್ಟು ಪೇಜ್ ಇದೆ ಅಷ್ಟು ಕಾಸ್ಟ್ ಕೊಡಿ. You never keep one copy with your BD officer. You don't retain. Is that your submission? Only the council retains, BDO doesn't retain a copy of the petition and annexes. Okay. You are making an allegation like that. Don't you keep a petition and annexures in the office, in the BDA's office, NIM office alla, BDA office. ಕೊಡಕ್ಕಾಗಲ್ವಾ ಅವ್ರು ನಿಮ್ಗೆ? We can direct them, but this is not in light of what has been observed last time, you should not be making this kind of. Otherwise, you can make this submission. Not in light of what has been observed. ಓದಿದ್ದೀರಾ ಲಾಸ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್? ಓದಿಲ್ಲ ಅಲ್ಲ, ಅದಕ್ಕೆ ಹೆಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಯಾವ ಫೈಲ್ ಮಾಡ್ತೀರಾ? 2015 matter. 2015 matter. We are not concerned about you. We are concerned about BDA. ಅದಕ್ಕೆ ಹೆಡ್ ಆಫ್ ಲೀಗಲ್ ಪ್ರೆಸೆಂಟ್ ಇಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಅವ್ರನ್ನೂ ಪ್ರೆಸೆಂಟ್ ಇಟ್ಟಿಲ್ಲ. Available warrant NBW. Shri B.S. Sachin seeks for and is granted 2 weeks time finally to file his objections on payment of cost of rupees. Somebody has to pay. Nimgal BD has to pay. Return refund.
3,000 I was made to.
Cost of rupees 3,000. The said cost to be remitted to the council for the petitioner within 1 week from today. Objections, if any, to be filed on or before 30th June 2022 after serving a copy thereof on the council for the petitioner released on 5/6/2022. If the objections are not filed in the given time frame, the head of legal cell BDA shall be present in this court. Though this court had wide order dated 24/5/2022 had directed the presence of head of legal cell Bangalore Development Authority in view of no objections having been filed for the last 7 years. Today, the head of legal cell BDA is not present. Though this court could have issued a bailable or a non-bailable warrant, it refrains from doing so, with the hoping and trusting that the objections will be filed by the next date. Yes. One and six. What is your representation? What is your prayer? Efforts? This is site number?
Site number 3.
Who have case for respondent number 7 you appear. What do you have to say?
The list of time the petition number 1747 disposed of on suspicion of the petitioner that there was fencing has been around the property. There was no any disturbance, and there was observation regarding this graveyard achieved. And we read paragraph number 4 of the petition, the section number C.
Yes.
C of the petition.
Yes.
It is a way to observe that there is a graveyard of the Muslims, and beside the graveyard, they have put the fencing around the property. And
Yes.
in order to be fair to the learned counsel for respondent 5, I was respondent 5 in that petition.
Yes.
And it's particularly mentioned that 5 photographs collected placed on document number 982E in the objection statement filed with the meeting applicant. Now respondent 5 was brought to our notice, defeating the existence of the graveyard on either side of the barbed wire fencing. It is therefore the contention of the learned counsel for respondent by the encroachment alleged by the petitioner still in existence, as is apparent from the photograph brought to our notice. It is, however, the contention of the learned counsel representing respondent by the entire graveyard is in consonance with the notification dated 9/7 to 2010, wherein Muslim graveyard Sunni Jamia Masjid Muhammad Saf Pandia, Bangalore has been depicted in survey number 57, 1 acre 1 gunta, survey number 56, 1 acre 25 gunta, and survey number 6, 1 acre 21 gunta. Insofar as the instant hospital matter is concerned, the learned counsel petitioner stated that Muslim graveyard Sunni is in different land other than the land reserved for the park. The park, which is the subject matter of the consideration, is in the real estate of the village Chikkabetta, Yelahanka, Bangalore. As such, has no relevance to the factual position. Highlighted by the learned counsel respondent 5. Having noticed the rival submission, comments of the hands of the learned counsel for the parties, emerging out of the submission about the learned counsel representative of 5, we are of the view that petitioner being satisfied that encroachment over the land in question have been removed, lands having been appropriately fenced with barbed wire, there remains no justification whatsoever to deal with the issue, which is not the subject matter of the price by the petition. Accordingly, we find no justification whatsoever dealing with submission, can also be asked to be learned counsel by give us the land other than the land which continues to park in question as the subject matter of consideration of the petition. According to the incident,
Respondent number 6 cannot do anything on this. You can, what mandamus can be issued? What can respondent number 6 do? Respondent number 6, inspector of police. Complaint on after disposal, you will have to go before the commissioner BDA and get the details, not.
they want to convert into civic evidence. This is a park area which is already handed over to the BPMP as per annexure the E to the E1 to the petition. Park area cannot be considered as a civic area.
The park area cannot neither be made a civic community nor used as a graveyard. That is for you and BBMP to take action, not for the police inspector. If some offense is in progress, then police. Past andre or what is the fact they'll have to ascertain. Mandamus cannot be given for this. You approach them, you will not approach them. Really, you bury police inspector complaint and you want to take action otherwise. You should not do this. It's nothing. It's only to put a chain link fence. That's already been done. Now your grievance is something else. Fence, Eastern grievance chain link. ಇವಾಗ ನಿಮ್ದು ಏನ್ ಗ್ರೀವೆನ್ಸ್ ಅದು ಆಗೋಯ್ತು. ಅದಾದ್ಮೇಲೆ ರಿಮೈಂಡ್ ಆದ್ಮೇಲೆ PIL ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು. This cannot be maintained. You can approach the petitioner before this court, seeking the following release. The grievance of the petitioner is that a civic community site has been made use of by respondent number 7 for the purpose of a graveyard, and as such he submits that the same could not be done, and further that the civic community site has to be made into a park and retained as a park. Correct. The release which have been sought for, the complaints which have been made are to respond number 6, Inspector of Police, alleging that the respondent number 7 is carrying out illegal activities. That is not the case. Having gone through the documents, I find that that is not the case, in as much as in an earlier occasion, when the petitioner had approached this court in WP number 17454 of 2000, this court had categorically come to a conclusion that the said civic community site had been fenced and there were graves found, park which has been fenced. Park or civic community? Civic community na iವಾಗ park ಮಾಡುವಂತ. The park had been fenced by a barbed wire and graves were found on both sides of the fence. And as such, the said writ petition, public interest litigation, was dismissed as infructuous. The very same grievance has been raised by the petitioner in the present litigation, which is not permissible. If at all the petitioner has any grievance, he has to agitate it before the respondent number 1 and 2. Hence, reserving such liberty, the petition is dismissed. Ready for argument ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. ರೆಡಿ ಫಾರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಟೈಮ್ ಕೇಳೋದು. Counsel for the respondent number 2 and 3 seeks for and is granted a week's time to file a list of authorities along with authorities which shall be also served on the counsel for the petitioner. The counsel for the respondent is also directed to secure the original records pertaining to the land in question, released on 28/6. Interim order earlier granted is extended to next day.
I appear for the respondent, Your Lordship, respondent BD.
You are appearing for respondent number 1, Mr. Kiran?
Yes, Your Lordship.
Shri Kiran CV has entered appearance for respondent number 1. Registry is directed to read the name of Shri M.N. Sudev Vegade and Basraj ST as that appearing for respondent number 1. Respondent number 2, HCG. ಹಾಕಿದ್ದೀರಾ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದೀರಾ? You are the third counsel appearing in this matter. You may empathize with your situation. 2018 was the first counsel who appeared. 4 ವರ್ಷದಿಂದನೂ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. We are not concerned about you, Mr. Basraj. We are concerned about BDA. ಇನ್ನ ನೆಕ್ಸ್ಟ್ 1 year ಆದ್ಮೇಲೆ ಇನ್ನೊಂದು ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡ್ತಾರೆ. ಅವ್ರು ಬಂದು ಹೇಳ್ತಾರೆ ಐ ಫೈಲ್ ವಕಾಲತ್ ಇದೆ ಅಂತ. We give them one more opportunity. We'll impose costs on. Argument ಮಾಡಕ್ ರೆಡಿನಾ?
Ready, Your Lordship.
ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ಬಿಡಿ. ಅಲ್ಲ ಇವಾಗ ಯಾರು ನೀವು ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ, ಕಿರಣ್ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀರಾ? Kiran, Mr. Basraj says he has entered appearance.
I have also filed a notice of account. If he is
You
appearing,
also filed wakalat.
much obliged.
He also will say the same thing, but ಒಬ್ರು ಯಾರಾದ್ರೂ appear ಆಗಿ.
That's let Basraj Jetty appear, Your Lordship. He has filed out.
ನೀವು ಅಪೇರ್ ಆಗ್ಲಿ ಅಂತ ನೀವು ಅವ್ರ ಪೈಲೆ ಅಂತ ಆಗುತ್ತೆ. ಹೊಡೆದಾಕಿ ಶ್ರೀ ಕಿರಣ್ CV as also Shri Basraj ST submit that they have filed their wakalat for respond number 1. Both the council submit that they have no objection for the other to appear in the matter. It is for the BDA to take a decision on the same. 2 weeks time is finally granted to file objections, statement of objections. Considering that Wakalatnama on behalf of respondent number 1 was first filed on 16/8/2018 by a council who retired, and thereafter another council came on record, and now the third council is coming on record. And during all this period of time, the objections have not been filed by the respondents. The statement of the time today granted is subject to payment of cost of rupees 5,000 to be remitted by the BDA. Released on objections, if any, to be filed on or before 30/6/2022, released on 5/7/2022. Memo of retirement to affidavit to application ಏನು ಇಲ್ಲ, ಸುಮ್ಮನೆ ಫೈಲ್ ಮಾಡಿ. Otherwise we will just dismiss. ನಾವಿಟ್ಟಲ್ಲ ಇವಾಗ ಫೈಲ್ ಮಾಡಿ ಪಾಸ್ ಹೋಗಿ. Some settlement talks were going on. Your settlement is here. Joint counsel for the petitioner submit that the settlement talks have failed. It's taken on the failed. Objections ಹಾಕಿದ್ದೀರಾ? ನೀವು ಹಾಕ್ಬೇಕಾ ಬೇಡವಾ? It has to be handed over. Nobody can have any objection.
I have no objection.
My legal settlement talks said.
STP is also, according to the information given to me, STP is also not yet.
STP is fully functional but not operational, because for the purpose of STP to operate, minimum 70% of the layout should be in after construction also should be ready. As of today, there is only 50 houses which are constructed.
So what is the sewerage facility at this layout?
The STP is already established. Obtaining consent from the Karnataka State Municipal.
So it is a soak pit and not connected to BWS.
It is fully, connected to, it should be, well, I have stated that CTP is, where payment to BWS also.
ಬರೀ ಪೇಮೆಂಟ್ ತಗೊಳೋದಷ್ಟೇ ಇರತ್ತಾ ಅಂತ ಇದೆಯಾ?
They have paid 20 lakhs to the pollution control board.
Pollution control board is only to give you a certificate. Sewerage line
is ready. My instructions are STP is ready. And but it is not operational as yet because there are only 50 houses in the layout.
So your contention is that you have completed everything that you have.
Everything is complete.
So they can always ascertain and ask you to do anything which you have not done.
They want to.
Other section 35 only they can take action. They will take action if they haven't done it. They will do it.
No, they are not maintaining the layout also. BDA. Though they are.
BDA hand over. BDA in the BDA maintain ಮಾಡಲ್ಲ. BDA ತಗೊಂಡ್ಬಿಟ್ಟು ಆಮೇಲೆ BBMP ನೋ ಯಾವ ಮುನ್ಸಿಪಲ್ ಅಥಾರಿಟಿ ಕೊಡುತ್ತೆ. ಮುನ್ಸಿಪಲ್ ಅಥಾರಿಟಿ ಅದು ಬರೀ ಕಲೆಕ್ಷನ್. ಅವ್ರ ಮೇಂಟೆನೆನ್ಸ್ಗೆ ವಿಂಗೇ ಇಲ್ಲ ಅಂತ.
May I submit?
Yes, Mr. Somyaji, you are appearing in this?
ಅಲ್ಲ, ಅದರಲ್ಲಿ ನನಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಥರ್ಡ್ ರೆಸ್ಪಾಂಡಿಂಗ್ ಅವ್ರೇನು ರಿಪೇರ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಕೊಂಡು ಹಿಂದೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಫೈಲು. ಅದಕ್ಕೆ ಬೇಕಾಗಿ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ರೆ.
ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
ಗ್ರಾಮ ಪಂಚಾಯತ್. ಹೌದು ಹೌದು ಹೌದು. ಅದು ಇವತ್ತು ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು. ಅಲ್ಲ, ಇವತ್ತು ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು. ಅದಕ್ಕೆ
ಅಲ್ಲ, ನಿಮ್ದೇನಿಲ್ಲ ಅಂತ BBMP ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸಂಬಂಧಪಟ್ಟಿದ್ದೀವಿ.
BBMP ಲಿಮಿಟ್ಸ್ ಅಲ್ವಾ ಇದು?
ಅಲ್ಲ 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 ಅಲ್ಲ.
They have to maintain. So, Somyaji, you will have to tell us who is going to maintain it and how.
ಹೌದು, ಅದೇ ನನಗೆ ಇನ್ನು ವಕಾಲತ್ ಕೊಟ್ಟಿಲ್ಲ. ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು ಅಷ್ಟೇನೆ. ಥರ್ಡ್ ರೆಸ್ಪಾಂಡ್ ಅವರೇನು ಲಾಯರ್ ರಿಪೇರ್ ಆಗೋದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹಿಂದೆ ಕೊಟ್ಟಿಯಾರಂತೆ. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ರೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಹೇಳ್ತೀನಿ.
26 Shri B. J. Somyaji, Learned Counsel, who appears through video conferencing, submits that he has been instructed to appear in the matter in the place of Shri H. Timmappa. Hence, registry is directed to show his name as that appearing for respond number 3 and delete the name of Shri H. Timmappa as that appearing for respond number 3. He is directed to obtain instructions from respond number 3 as regards the mode and methodology of maintenance of the layout of the petitioners and make his submissions. Relist on 28/6. You are appearing for respond number 4. Mrs. Vanaja. Idara.
Challenging information of site number 135. In case of the petitioner, that the site has been found on the road affecting my property in the public site. The allotment of the site number 135, which is other two roads that are on the phone.
Yes. So you say that it's been formed on a road.
Yes, I will permit and take as of the case. 3/3/2004, page number 13. My predecessor title was allotment other the property and auction sale. Page number 13.
ಯಾವ ಸೈಡ್ ಬರುತ್ತೆ ಇದು ರೋಡ್?
Move side road.
3 ಸೈಡ್, ಮುಖ್ಯ ರಸ್ತೆ, ಅಡ್ಡ ರಸ್ತೆ, ಅಡ್ಡ ರಸ್ತೆ. ಯಾವ ಕಡೆ?
Northern side ಅಲ್ಲಿ 4BC, 4B cross road.
ಉತ್ತರಕ್ಕೆ 4ನೇ B ಅಡ್ಡ ರಸ್ತೆ.
4ನೇ B ಅಡ್ಡ ರಸ್ತೆ. This is the site on which they include this now. This road, on this road, they have found the site number 135. But after this purchase under the auction method. There was one more sale date, 12/8/2008. The original purchaser unable to sell transferred the property to one Syed Mullah. Actually, see page 21 method. Even in all the sale deeds, these sites also are closed. Not even put in there.
This is your possession, no? Where the sale deed in
Sale deed is at page number 14 onwards. Page number 18 is the BA sale deed.
EJ Hussein. ಉತ್ತರಕ್ಕೆ 4ನೇ ಬಿ ಅಡ್ಡ ರಸ್ತೆ.
Page number 18 lot of find
Measurement is 5.20 by 2, totally 49.77, 490 square feet.
Then the next document is the connection of page number 21 Malad, it's the second sale. From Anil Hussain to one Syed Muhammad. The same people is extracted. Schedule is at page number
32. Yes. 32 ಇಂದ ಮತ್ತೆ ಇನ್ನೊಂದು ಸೇಲ್.
we have constructed a house thereafter. And then I have purchased it along both the sides of the residential building on that. My credit is at page number 34. My purchase was on 11/4/2011.
So as per your annexure E, it is on the northern side, on the left side of your side, there is a site form.
All three sites may not have affected. No, my lord, thereafter and BD after 15 years, got 2018, claims that they have formed the road on this fourth cross road method. And they have allotted it in favor of respondent number 3.
They formed a road and allotted the road.
On the site on the road.
ಎಲ್ಲಿ ಹೇಳ್ತಾರೆ ಅದು? ದಕ್ಷಿಣಕ್ಕೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 4BC 134.
All along it was a partner site. Even that was how it was advertised. It was advertised to be awarded by three side board. Thereafter, respondent number 3 sends this site to.
Where is the advertisement? Advertisement ಎಲ್ಲಿದೆ?
Advertisement not my site advertisement.
Very corner site ಅಂತ ಹೇಳ್ತಾರೆ. They don't give the boundaries. ಇಲ್ಲೇ ಇದೆ, ಪ್ಲಾನೇ ಇದೆ ಅಲ್ಲಿ 4BC 134. All three sides are good.
So now, statement of objection is filed by BDA. Para 7 they can be using for what justification here. BDA statement of objection para 7.
When was it filed?
Statement of objection by BDA.
Yes. Sarah? It is no doubt.
It is no doubt that the sale is executed by second respondent, the BDA. The opposite option purchaser shows the site number 4BC 134. The adequately site road and the original plan also shows the road. But after full formation of the layout, there was strong water running west to east along with BDA left property. After forming the layout, even if road continues, it is 4 feet continues, it will become the dead end of the road as per the tree. As per the private apartment, multi-story building has been given by the High Court in the tribunal number 414. A copy of the judgment is enclosed as annexure R2. It is expected that the respondent government is directed to consider the representation given by the association and to pass appropriate orders in accordance with the provisions of law. And also, if there are instances where an allotment has been made, time of compliance is 8 weeks from today. In view of the above direction, the second respondent video was under pressure to find places for allotting sites to economically weaker second categories. Wherever the media property was available, this respondent farmed the sites and allotted 30 sites to EWS category. A list of sites allotted to EWS category is enclosed as annexure 3, which includes site number 1 GM 135. On the northern side of site number 4 BC, the second respondent BDA property, as the property cannot be used for any other purpose, maybe respondent BDA. The respondent submits this respondent has neither acted nor formed any sites and allotted any sites to any people illegally. It is further submitted that this respondent acted in accordance with law and the direction given by the Honorable Court and fulfilled the obligation. Now they are trying to take shelter and obey orders of the Honorable Court by law.
What is the representation of the association in the BP
Association
number?
had given a representation that had approved the Honorable Court for writ of mandamus to consider that representation, and a direction was given to consider that matter. However, they have said that.
No, what was the representation? What was the representation?
Page number 8 may can you see the representation they are not produced. It is given by the petitioners in that petition. Page number 8 annexure R2.
Right, but unless you know what the representation is, how do we consider it?
Silver on the list on backward class welfare association, page 8 R2 will not they have given it. The lordship look at page 3. The same allowed in cooperative law. Therefore, the letter was given on 8 December 2007 to the urban development department of written the letter to mediate consider the representation of the association. No order has been passed in now. Appeal this action representation filed with the letter of mandamus. In paragraph 2, the petitioner has not stated as to under what provision of law the said representation has been made. Unless statutory duty is pointed out, mandamus cannot be issued. Over submission is made by the 11 months for the petitioner. A similar prayer have been considered by the respondent pursuant to representation given, and allotments have also been made. In view of the submission, the respondent government is directed to consider the representation given by the association and to pass appropriate orders in accordance with the provisions of law. And also, if there are instances where nearby allotments have been made, then for compliance with the 8 weeks from today. They are now taking credit of this order, and they claim that they have farmed sites wherever it is possible. And this portion of the property method is actually a road, even according to the records, the layout plan, and also the now they will not as per R3 will not they have farmed certain sites.
Yes, madam.
Thereafter, the matter is hearing. And yes, instructed me to for engineers to visit the spot and find out the position. Thereafter, I submitted they are present and the petitioner then imposed the media of law. We have given the full. And because of that, only that I got allotted to the.
Where have you filed your report?
Yes, I have filed.
Submitted.
On which date was it submitted? Yes, land inspection report.
And along with the photograph.
So according to you, 0.2 meters has been encroached.
Yes, at least it goes.
So what is the direction which is given to you to do? ನಿಮಗಲ್ಲ ನೀವು ಆಮೇಲೆ ಬರ್ತೀವಿ ಫಸ್ಟ್ ಅವ್ರು ಬರ್ಲಿ. Yes, madam. Now, when you formed the site 135, was the layout plan modified? Really the plan? Where is the plan? Why? You were asked to produce it.
Taking advantage of the open space, the petitioner has enforced the BA property. And
Madam, these proceedings are as regards the site formed by you. If they are formed, if they have enforced, you initiate proceedings against them. That is not the argument that can be heard in this matter. Please first justify your action. Offense is the best form of defense, Bada. First, you are in the defending thing. First, defend yourself. How did you form that site?
because the full formation of the plan was not, and I have to release the plan also. They are adopting.
Really, the modified plan. Really. Where is the sanctioned modified plan?
I have produced. Actually, today, because the matter was not taken up for okay, I have not brought the original account. I can produce the original with all the plans and all that. And we have formed the modified plan, and because the layout, there was a BDA property left out. So due to this position, they have 20-30 sites was and form. Wherever, whatever
You can't go on forming wherever you want sites after having sold. You can't do that. If you are under the impression that you can do wherever you want it, you are wrong impression. You have sold it with this, seeing that people have paid money. You cannot change it later.
He has not changed the place.
You have changed it. He has not changed. You have changed it.
We have allotted aspect for him.
Yes, you want time to produce it.
Yes, I can produce whatever because
Please produce it next week. We will take it up and then pass all this which are required. Yes, please.
There was an annual purchaser there, my respondent number 4 after the award.
If you have any grievance, if we allow this, if you have any grievance, you can proceed against BDA for having wrongly sold it to you. Is it a parted matter? Please don't make submission that it was heard like this. This was submission. You can't.
Because they are rivals. Is there any chance of some settlement or where all this will not?
ನೀವು ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂತೀರೋ ಮಾಡ್ಕೊಳ್ಳಿ. ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಎವ್ರಿಬಡಿ ಇಸ್ ಹ್ಯಾಪಿ. ನೀವು ಹ್ಯಾಪಿ, ಅವರು ಹ್ಯಾಪಿ, ಬಿಡಿಎನು ಹ್ಯಾಪಿ. ನೀವು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಹೇಳುದು ಅವರು ನನಗೆ ಏನು ಹೇಳಿಲ್ಲ, ನಾವು ಏನಾದ್ರು ಹೇಳಿದ್ರು ನಾನು ಹೇಳ್ಬೋದು ಅಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅವ್ರಿಗೆ
We would welcome a settlement. ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ. ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. We are not going to keep matters pending. That's all. ನೀವು ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ. If they are right, they will get an order in their favor. If you are right, you will get an order.
That was only as you watch it directed.
Actually, BDA has to say whether they have done it right or wrong. It all depends on BDA. Ms. Vanaja, learned counsel for the BDA, submit that today she is not carrying the file containing the modified plan sanction and other documents. Then she seeks for a week's time, released on 21/6/2022. 28/6/2022. 28/6 madam. 28. 27th alla 28. BDA matters are only on Tuesday. Two bar one. Yes. You are asking this road through the property of the apartments on top? Then they have to be made a party. Hmm. Number survey number 2/1. 2/1. 12-meter wide RMP road from the 15-meter road. What is this, page 9? ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಮ್ಯಾಚ್ ಆಗ್ತಾ ಇಲ್ವಲ್ಲ. Page 8 and 9. Yes.
Before changing of the plan of the
Page 8 ಆಮೇಲೆ page 9 ಮಾಡಿದ್ದೀರಾ?
Now it is before it was in the vessel and access is there for the
ಈಗ ರೋಡ್ ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? ಇಲ್ಲ ಇನ್ನ ಪ್ಲಾನಿಂಗ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ. This may be a better road if they are giving you a
as per page 9,
we'll record that statement. We'll record that statement. ಯಾರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿದ್ದು ನಿಮ್ಗೆ? ಇನ್ನೇನಿಲ್ಲ, ಅವ್ರು ವೆರಿಫೈ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ ನಿಮ್ ಸಬ್ಮಿಷನ್. Shri V.S. Sachin, learned counsel submits that the proposed road in terms of page 9 of the writ petition has in fact been formed, and there is a 12-meter wide RMP road access provided to the land in survey number 2/1 belonging to the petitioner on the eastern side, which connects to the 15-meter wide RMP road. Shri A. Sampath seeks for and is granted. First verify ಮಾಡಿ ಇದೆಯಾ ಅಂತ ಅಲ್ಲಿ ಇರುವೆ ಇಲ್ಲ. We'll respond 21st. What about who is appearing for the respondents? So DP Prasanna Kumar illu alla ivaga. He's not on the panel. Mr. Vachan, Mr. Prasanna Kumar is not on the panel. So DP Prasanna Kumar is not in the panel. Maybe Manjunath, respond number 5 where? Shri DP Prasanna Kumar is no longer on the panel of the BBA. Hence, Shri N.R. Girish is directed to accept notice for respond number 4. Register to print his name as that appearing for respond number 4. Released on 28/6. One copy ಕೊಟ್ಟು ಬಿಡಿ NR ಗಿರೀಶ್. 28. ಇನ್ನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ವಾ ಮತ್ತೆ? ನೀವು 2 weeks ಅಂದ್ರೆ ಕೊಡ್ತಾ ಇದೀವಪ್ಪ. ಇನ್ನ 3 weeks ಅಂದ್ರೆ 3 weeks ಕೊಡ್ತೀವಿ. ಒಂದೇ ಸತಿ ಟೈಮ್ ಕೇಳ್ಬೇಕು 3 weeks ಅಂತ. ಸುಮ್ಮನೆ ಲಿಸ್ಟ್ ಆಗತ್ತಪ್ಪ. Let them make their submission. ನಿಮ್ಗೂ ಗೊತ್ತು, ನೀವು ಈ ಸೈಡ್ ಇದ್ದಾಗ ಏನಾಗುತ್ತೆ ಅಂತ. ಅವ್ರ ಕಷ್ಟ ಅವ್ರಿಗೆ ಗೊತ್ತು. ಬಟ್ ಇನ್ಮೇಲೆ 3 weeks ಕೊಡೋಣ ಎಲ್ಲದಕ್ಕೂ. So that it saves that nimgu embarrassment saved. Alva. G. Lakshmi Rao seeks for and is granted 10 more days to file statement of objection. Released on objections to be filed on for 23/6, released on 28/6. Shivkumar rental appearance for Devareddy no nim colleague alla. Shivkumar and Devareddy CR have entered appearance for the petition. Hence, registry direct delete the name of Shri Mohammed Ayub Ali as that appearing for the petitions. Shri Rudrappa P has entered appearance for the petitioner. Registry is direct to delete the name of Shri Syed Abdul Sami as that appearing for the petitioner. File Mr. Rochan. Okay. So when will you get this plan? When will you get it? B. Vachan, Learned Council submit that. ಇವಾಗೆಲ್ಲ ಒಂದೇ ಫ್ಯಾಕ್ಟ್ ಬರ್ತಾ ಇದೆ. ಇವಾಗ ವಚನ್ ಅವರು ಎಲ್ಲ ಪಾಪ ರಾತ್ರಿ ಎಲ್ಲ ಕೂತ್ಕೊಂಡು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನ. ಅವ್ರ ಕಷ್ಟ ಅವ್ರಿಗೆ ಗೊತ್ತು. Seeks for and is granted 2 weeks time finally to file 10 days time finally to file a statement of objection. Objections to be filed on or before 23/6, released on 28/6. Objections ready now? ಯಾವಾಗ? None appears for the petitioner today also. If none were to appear for the petitioner, the next day the petitioner will be liable to dismiss for non-prosecution. Released on 28/6. Conflict. The in charity seeks for and is granted 2 weeks time. Finally, to file a statement of objections. Objections if 10 days time. Objections if any to be filed on or before 23, release on 28. Interim order earlier granted. ಅವರು ಇರ್ಲಿಲ್ಲಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್. None appears for the petitioner, nor are the copies of the petition along with annexure furnished on the counsel for the respondent. Released on 28/6 for the doing issue. Just 3 months. Petitioner is before this court seeking for the following reviews. The petitioner was allotted a site bearing number 45, 4H block, Banshankari, further extension 6 stage, measuring 12 into 9 meters, and the allotment letter dated 7/2/2004. As regards this, the petitioner has made payment of the entire sale consideration, and the sale deed also came to be executed in favor of the petitioner on 15/2/2005. Subsequent thereto, it came to be realized that the land on which the said site had been formed was forest land. ಹಿಂಗೆ ಮಾಡ್ತೀರಾ? The private individual or anybody, 1 inch ಈ ಕಡೆ ಆ ಕಡೆ ಹೋದ್ರೆ ಅಷ್ಟು ಇದಾಗುತ್ತೆ. ನೀವು ಎಷ್ಟು ಈಸಿಯಾಗಿ ಮಿಸ್ಟೇಕ್ ಅಂತ ಹೇಳ್ಬಿಡ್ತೀವಿ. ಎಷ್ಟು ಜನ ಇದು? It has gone through so many people and then you just say it's a mistake. And petitioner has been suffering from 2004. 18 years, majority agate, site allotment. ಒಂದು ಸೈಟ್ ತಗೊಂಡಾಗ ದುಡ್ಡು ಕೊಟ್ಟು ಎಲ್ಲ ಮಾಡಿ ಸೇಲ್ ಡೀಡ್ ಆಗಿ 18 years ಆದ್ರೂ ಇನ್ನ ಕಾಯ್ಬೇಕು ಅಂದ್ರೆ ಅಲಾಟ್ಮೆಂಟ್ ಸಿಗದೆ ನಿಮ್ಮ ಹತ್ರ ಕಷ್ಟ. ಎಷ್ಟನೇ ಸತಿ ಮಾಡಿದ್ರೆ? 5ನೇ ಸತಿನ 6, 7, 8 ಫಿಫ್ತ್ ಟೈಮ್ ಹೋದ್ರೆ ಹಿಂದೆ ಇಟ್ ಗೋಸ್ ಬ್ಯಾಕ್ ಟು 30 years. ಕಷ್ಟ ಇದೆ. Forest was part of the Turaldi Forest Reserve, and as such, the petitioner could not make use of the said site. Thereafter, the petitioner has given various representations to the respondents to allot alternate sites, which also has not been acted upon by the respondent. Hence, the petitioner elected no other alternative before this court. It is rather shocking that the BDA has formed the state has acquired land belonging to which has been designated as forest, and BDA has formed sites in forest land, allotted the same to innocent applicants like the petitioner, collected the monies, executed sale deed, and thereafter claims that it is by way of mistake that the site could not be, that the petitioner, that site was by way of mistake that the site was found and the petitioner cannot make use of the said site. The Commissioner BDA is directed to look into the matter and take necessary action against all concerned persons. Considering that it is solely on account of the mistake of the BDA that the petitioner has been made to suffer, it was but required for the BDA to have acted on the representation within a reasonable period of time, which also has not been done. The representations at Annexure L was submitted on 10/7/2000. M series. M series was submitted on way back on 10/7/2018, followed up with several other representations. This is a complete dereliction of duties on part of the concerned authorities. You are paying on that side. Very sad. Can't be made to suffer like this. Should have been acted upon within a reasonable period of time. The Commissioner BDA is directed to inquire into the matter as regards the persons responsible for not acting on the said representation and take necessary action against them. Any representation and or application submitted to any authority is required to be acted upon and orders passed thereon within a reasonable period of time, either accepting or rejecting the application. If no orders are passed by the concerned authority, the same would amount to dereliction of duty, requiring initiation of disciplinary proceedings. The Commissioner BDA is also further directed to set up a system for monitoring the application and representation received by the BDA, so that the status of the said representation and our application can be ascertained and the persons responsible for the delay be identified and action taken against them. In this connection, necessary use of the information technology tools which are available would also be required to be made use by the BDA, including the implementation of an e-office, e-office software for monitoring the receipt of the applications and or representations. A status report regarding the above to be submitted by the Commissioner of the respondent within a period of 4 weeks from today, that is on or before 19/7/2022. In view of the above, I pass the following order. The respondent is directed to consider the representation of the petitioner at Annexure M series within a period of 3 weeks from today. 3 weeks from today, and allot an alternative site. The alternative site, preferably within the same day, within the set period. Though the petition is disposed, released on 19/7/2022 to report compliance. 2 ವರ್ಷ ಆಗಿದೆ ಕೃಷ್ಣ, 2004 ಇಂದ they don't require that much time. We should work. No 19th ಒಳಗೆ ನೋಡೋಣ. 5 weeks ಆಯ್ತು 19th ಅಂದ್ರೆ. 4 weeks. DP Prasanna Kumar Bere. Okay, 31. Okay, objections. ಆಯ್ತು, ಇವಾಗ ಹೇಳಿ ಅಬ್ಜೆಕ್ಷನ್. ಫೈಲ್ ಮಾಡಿದ್ರೆ ಏನಮ್ಮ ಆಯ್ತು? 31 28(6) ಆಯ್ತು. ಹೊಡೆದಾಕ್ಬಿಡಿ, NR ಗಿರೀಶ್ ತೆಗೆದಾಕ್ಬಿಡಿ. ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ರಿಲಿಸ್ಟ್ ಆನ್ 28(6). So now DP Prasanna is different, P Prasanna Kumar is different. ನಿಮ್ಗೆ ಅರ್ಜೆಂಟ್ ಇಲ್ಲ, ನಿಮ್ಗೆ ಅರ್ಜೆಂಟ್. ನೀವು ಅಡ್ವೊಕೇಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದ್ದೀರಾ? ಅಡ್ವೊಕೇಟ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿದ್ದೀರಾ ಕೋರ್ಟಲ್ಲಿ? ಮಧ್ಯಾಹ್ನ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡಿ ಹೇಳಿ. ಯಾವ ಕೊಲಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ, ನಿಮ್ಗೆ ಇಮಿಡಿಯೇಟ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ. All the order sheets come to you. You don't need to ask anybody. ಮಾಡಿ ಹೇಳ್ತೀರಾ ಮಧ್ಯಾಹ್ನ? ಬಂದ್ಬಿಟ್ಟು ಕೋರ್ಟ್ ಆಫೀಸರ್ಗೆ ಹೇಳ್ತಾರೆ, ಬರ್ಕೊಳ್ಳಿ. Learned counsel for the petitioner submit that you will be furnishing copies of the petition along with annexures to the learned counsel to respond by end of the day today. Learned counsel for the respondent seeks for and is granted 3 weeks time to file a statement of objection. Objections, if any, to be filed on or before 7/7/2022, released on 12/7/2022. ಯಾರ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಇದ್ರಲ್ಲಿ? ಭಾರ್ಗವ್ Dina Gina. Shri Bhargav ji has entered appearance for the petitioner and his registry is directed to delete the name of Shri C.R. Gopal Swami is that appearing for the petitioner. None appears for the petitioner. Learned counsel for the respondent submit that he is not been served with copy of the petition. Counsel for the petitioner is directed to furnish copy of the petition along with annexures on counsel for the respondent by 21/6/2022. 3 weeks time thereafter is granted to the respondent to file a statement of objection. Statement of objections, if any, to be filed on or before 15/7, released on 19/7. Objections to be filed on or before 9/6. You asked, you mentioned and sought time last time. ಟೈಮ್ ಕೇಳಿದ್ಮೇಲೆ ನೀವು ಏನ್ ಟೈಮ್ ಕೇಳ್ತಾ ಇದೀವೋ ಅದು ಕೊಡ್ತಾ ಇದೀವಿ, ಅಷ್ಟಲ್ಲಿ ನೀವು ಮಾಡಿ. 2 weeks ಅಂದ್ರೆ 2 weeks ಅಂದ್ರೆ 3 weeks ಅಂದ್ರೆ 3 weeks. But again, if it gets adjourned, ಈ ವೀಕ್ ವಿ ಆರ್ ಅಡ್ಜರ್ನಿಂಗ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಮತ್ತೆ ಯಾರು ಟೈಮ್ ಕೇಳಿದ್ರೆ ಅವಾಗ ಈಚ್ ಮ್ಯಾಟರ್ ವಿಲ್ ಇಂಪೋಸ್ ಕಾಸ್ಟ್. ಯು ವೋಂಟ್ ಲೈಕ್ ಇಟ್, ಬಟ್ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಇಂಪೋಸ್. 1 week ಅಲ್ಲಿ ಆಗಲ್ಲ, ಅದಕ್ಕೆ 2 week ಕೊಡ್ತೀವಿ. ಕಾಪೀಸ್ ಎಲ್ಲ ಬಂತ? Shri N.R. Girish, learned counsel for the respondent once again seeks for a short accommodation to file his objection. No, though no such accommodation is required to be entertained, 10 days time is finally granted to the respondent to file a statement of objection, which shall be filed on or before 23/6, released on 28/6. ಸೇಮ ನೋಡಿ, ಇವತ್ತೆಲ್ಲ ಅದೇ ಕಥೆ ಆಗ್ತದೆ. Same, Shri ST Basura seeks for 10 days, 23, 28. Seeks for 3 weeks. Statement of objections, if any, to be filed on or before 7/7, released on 12/7. Lakshmi. None appears for the petitioner. Copies of the petition have also not been served. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. We listen to 28/7/6.
I appear for the petitioner.
Ready? File ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Sir ಮಾಡಿದಿರಪ್ಪ. You received?
Yes, yes, I received.
Ready na?
Mail. Yes, sir.
You ready na argument? We'll take it up at 2:30.
Yes, very well.
$45. Okay. ಯಾವ ಫೈಲ್ ಮಾಡ್ತಾರೆ? Learned AG is Shri B. Krishna, learned AG is directed to take notice for respond number 1. Shri Piyush Kumar Jain has entered appearance for the petitioner. Registry is direct delete the name of Shri Ruben Jacob as that appearing for the petitioner. Shri N.R. Girisha seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, to be filed on before 36/2022, released on 5/7/2022. Yes, Mr. Ola? Huh? 1 week's time. Objections there? File ಮಾಡಬೇಕಾ ಮಾಡಿದಿರಾ? Gautam Dev seeks for and is granted 1 week's time to file a statement of objection. Statement of objection, if any, to be filed on or before 23/6, released on 28/6. Shri Lakshman Negde seeks for and is granted 3 weeks time to file a statement of objection. Then to be filed on or before 5/6/7, released on 12/7.
Court officer, sir.
52 ತಗೊಂಡ್ರಾ?
ಸರ್ ಹೇಳಿ.
52 ತಗೊಂಡ್ರಾ?
52 ತಗೋತಾರೆ ಸರ್, ರೀಚ್ ಆಗುತ್ತೆ.
ಓಕೆ.
ಮೇಡಮ್ 33 ಏನಾಯ್ತು ಮೇಡಮ್? 33
ನೆಕ್ಸ್ಟ್ ಡೇ 28/6.
28/6
ಇದ್ರಲ್ಲ ರುದ್ರಪ್ಪ ಲಿಸ್ಟ್ 2 ಸರ್? ಲಿಸ್ಟ್ 2 ಲಿಸ್ಟ್ 1?
ಲಿಸ್ಟ್ 1
ಇದ್ರಲ್ಲ ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ರುದ್ರಪ್ಪ ಅನ್ನೋರು ಇದ್ರು.
ಕೋರ್ಟ್ ಆಫೀಸರ್
28 ಹೋಗಿದ್ಯಾ?
ಹೇಳಿ. ಹೌದು.
ಲಿಸ್ಟ್ 26 ಏನಾದ್ರು ತಗೊಳ್ತಾರಾ? ಐ ಮೀನ್
ಎಲ್ಲ ತಗೋತಾರೆ ಸರ್. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
ಪ್ಲೀಸ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಮೇಡಮ್ ಲಾಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಯಾವ್ದು ತಗೊಂಡಿದ್ದು?
ಸರ್ 44.
ನೆಕ್ಸ್ಟ್
44 ಪಾಸ್ಡ್ ಓವರ್ಸ್ ಇದೆ ಸರ್. 4 ಇದೆ.
ಅದಾದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಮೇಡಮ್?
ಹೌದು. ಹಂಗೆ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ, ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್.
ಥ್ಯಾಂಕ್ ಯು.
ಹೇಗಿದ್ದೀರಾ? ತುಂಬ ವರ್ಷನೇ ಆಗೋಯ್ತು ಮಾಡಿ. ಇಲ್ಲ
ಇವಾಗ ಇಲ್ಲೇ ಕೋರ್ಟಲ್ಲಿ 21ರಲ್ಲಿ ಇದಕ್ಕೆ ಇದರೊಳಗೆ ಸಿಸ್ಟಮ್ ಅಲ್ಲಿ ಸೌಂಡ್ ಬರ್ತಾ ಇದೆ. ಯಾವುದು ನಿಮ್ಮ ಹಾಲಿನ ಟೀಚಿಂಗ್ ಅಲ್ಲೇ ಸೌಂಡ್ ಬರ್ತಿರೋದು. ವಿ ಅಂತ ಹಮ್ಮಿಂಗ್ ಸೌಂಡ್. ಗೊತ್ತಿಲ್ಲ. ಬಟ್ ಬ್ಯಾಕ್ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಬ್ಯಾಕ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, ಅದು ಆ ಪಾಯಿಂಟ್ ಕನೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಈ ಸ್ಪೀಕರ್ ಸೌಂಡ್ ಬರುತ್ತೆ ನಮ್ಮ ಆಂಪ್ಲಿಫೈರ್. ಒನ್
ಸ್ವಲ್ಪ ಇಂದ ಓಲಿ ಕಮ್ಮಿ ಮಾಡಿದ್ರೆ ನೀವು ಹೆಂಗೆ ಇತ್ತು ಸರ್?
ಫಿಲ್ ಮಾಡಿದ್ರಾ? ಓಕೆ. ಇದು ಬರುತ್ತೆ. ಇದು ಸ್ಪೀಕರ್ ಅಷ್ಟೇ.
ಇಲ್ಲಿಂದ ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕು.
ಸ್ಪೀಕರ್ ಅಷ್ಟೇ
ಗುರುಗಳು ಇಲ್ಲಿಂದ ಕನೆಕ್ಟ್ ಮಾಡ್ಬೇಕು.
ಓಕೆ. ಇದು ಓಕೆ. ಈಗ ಸ್ಪೀಕರ್ ಅಷ್ಟೇ ಬರುತ್ತೆ. ಅದು ಮೀಡಿಯಮ್ ಲಾರ್ಜ್. ಓಕೆ. ಹಲೋ ಸರ್.
ಇಲ್ಲಿ ಬಂದಿಲ್ಲ, ತಗೊಂಡಿಲ್ಲ. ಇಲ್ಲಿ ಹಾಕಿದ್ರೆ ಬರೋದು.
ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಪೋರ್ಟಲ್ ಇಂದ? ಸರ್ ಮಾತಾಡಿ ಸರ್. ಯಾರಾದ್ರು? ಅದು
ನಥಿಂಗ್ ಬಟ್ ಆಕ್ಚುಲಿ ಯಾವ್ದು ತಗೊಳ್ತಾ ಇದ್ದೆ? ಲೋಕಲ್ ತಗೊಳ್ತಾ ಇದ್ದೆ. ಇಲ್ಲಿ ಹಾಕ್ತೀನಿ. ತೆಗೆದ್ರಲ್ಲ? ಅಲ್ಲಿ ಲೈನ್ ಔಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಲ್ಲ. ಔಟ್ ಹಾಕ. ಅಲ್ಲಿ ನೀವು ಇದನ್ನೇ ಕೊಟ್ಟಿದ್ದೀರ ಸಿಸ್ಟಮ್ ಯಾಕಾಯ್ತು? ಸಡನ್ ಮಾಡಿತ್ತು. ಸಡನ್ ಮಾಡಲ್ಲ. ಅದು ಪವರ್ ಕೊಟ್ರಾ? ಆಕ್ಸಿಜನ್
ಗೊತ್ತಿಲ್ಲಲ್ಲ ಮೇಡಮ್. ಯಾವ್ದವರು ಯಾವ್ದಕ್ಕೆ ಪ್ಯಾನಲ್? ದಿಲ್ದಾರ್ ಶಿರಳ್ಳಿ. ದಿಲ್ದಾರ್ ಶಿರಳ್ಳಿ. ಹಾ, ದೇವದಾಸ್ ಅಲ್ಲ, ದಿಲ್ದಾರ್ ಶಿರಳ್ಳಿ.
ಸರ್ ಹೀಗೆ ಮಾಡಿಸಿ. ಸರ್ ಸರ್ ಹಾಕಿದ್ದೀರಾ ಇದು? ನೀವು ಹಾಕಿದ್ದೀರಾ? ಸರ್ ಆಕ್ಸ್ 2 ಹಾಕಿದ್ದೀರಾ? ಏನು ಕ್ಲೇಮ್ ಮಾಡಿ ಸರ್. ಬಂತಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ ಬರ್ತದೆ?
ಅಲ್ಲ ಬೇಡ ಇದು ಬರಲ್ಲ ಶುದ್ಧ ಬರಲ್ಲ.
ಪುಷ್ ಮಾಡು. ಕೊಡು. ಯಾವ್ದು ಬಂದಿಲ್ಲ.
ಸರ್ ಒಂದು ನಿಮಿಷ ಹಂಗೆ. ಹಲೋ ಸರ್. ಅದು ಆಕ್ಸಿಗೆ ಹಾಕಿ ಏನು ರಿಸೀವ್ ಮಾಡ್ತಿದ್ದಾರೆ.
ಹಲೋ ಹಲೋ ಹಾಂ ಹೇಳಿ.
ಇದನ್ನ ಇಲ್ಲಿಂದ ಔಟ್ ಮಾಡಿಸ್ಬೋದು ಅಷ್ಟೇ. ಫ್ರೀ ಔಟ್ ಇದೆಯಲ್ಲ ಅಥವಾ ಇದ್ರದ್ದು ಔಟ್ ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಹಾಕಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಅದು ಇದು ಮೈಕಿಂಗ್ ಬರುತ್ತಲ್ಲ. ಅಲ್ಲ ಒಂದು ನಿಮಿಷ ಅದನ್ನ ಇರ್ತು ಫ್ರೀ ಔಟ್ ಅಥವಾ ಮೈಕ್ ಔಟ್ ಇದೆಯಲ್ಲ ಅದು ಲೈನ್ ಔಟ್.
ಇಲ್ಲ ಅದು ಕ್ಲೀನ್ ಮಾಡಬೇಕು.
ಲೈನ್ ಔಟ್ ಲೈನ್ ಔಟ್ ಅಂದ್ರೆ ಅಲ್ಲಿಂದ ಔಟ್ ಆಗುತ್ತಾ? ಏನು ಇಲ್ಲಿಂದ ಔಟ್ ಆಗುತ್ತೆ? ಅಲ್ಲಿಂದ ಔಟ್ ಆಗುತ್ತೆ. ಅಲ್ಲಿಂದ ಔಟ್ ಆಗುತ್ತೆ. ಸರ್ ವಾಯ್ಸ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಪೋರ್ಟಲ್ ಇಂದ?
ಕೇಳಿಸ್ತಾ ಇದೆ, ಸೌಂಡ್ ಬರ್ತಾ ಇದೆ ಸ್ವಲ್ಪ.
ತುಂಬಾ ಸೌಂಡ್ ಇದೆ ಸರ್.
ಸ್ವಲ್ಪ ಇದೆ. ಈಗ ಹೋಯ್ತು, ಈಗಿಲ್ಲ, ಈಗ ಬಂತು. ಜಾಸ್ತಿ ಸೌಂಡ್. ಈಗ ಸರ್ ಆಯ್ತು.
ಓಕೆ ಸರ್, ಹಾಗೆ ಲೈನಲ್ಲಿ ಇದೆ ಸರ್. ಸ್ವಲ್ಪ ಇದು ಅದು ಔಟ್ ಆಪ್ಷನ್ ಕೊಡ್ಬೇಕಲ್ಲ ಸರ್ ಇದು.
ನೋಡಿ ಚೇಂಜ್ ಮಾಡಿ. ನೀವು ಮಾಡಕ್ಕಾಗತ್ತ ನೋಡಿ. ನೀವು ಮಾಡಿ
ಮೈಕ್ ಅಂತ ಹಾಕಿದ್ರೆ ಏನ್ ಹಾಕಿದ್ರಿ?
ಇಲ್ಲಿ ಸ್ಪೀಕರ್ ಅಥವಾ ಸೇವ್ ಸಿಸ್ಟಮ್ ಎರಡು ಬಂದಿದೆ
ಸರ್. ಮಾತಾಡಿ ಸರ್.
ಹೇಳಿ, ಕೇಳಿಸ್ತಾ ಇದೆ.
ಇಲ್ಲ.
ಹಲೋ
ವಾಲ್ಯೂಮ್ ಕೊಡಿ.
ಹಲೋ ಹಲೋ
ಹಲೋ ಸರ್, ವಾಯ್ಸ್
ಕೇಳಿಸ್ತಾ ಇದೆ ರೀ. ಹಲೋ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಹಲೋ ಸರ್.
ಕೇಳಿಸ್ತಾ ಇದೆ. ಹಲೋ
ಆಯ್ತು ಬಿಡಿ.
ಸರ್ ಆಯ್ತಾ?
ಸರಿ ಹೋಯ್ತು ಸರ್. ಸರಿ.
ಹಾ ಸರ್ ಆಯ್ತಾ?
ಹಾ ಸರ್.
ಓಕೆ ಓಕೆ.
ಇನ್ನೂ ಬಂದು ಎಕ್ಸ್ಪ್ಲೇನ್
ತಗೊಂಡ್ಬಿಡಿ ಸರ್, ನಾನು ಹಾಕ್ಬಿಟ್ಟು ಮಾಡೋಣ.
ಎಲ್ಲಿ ಮಾಡ್ತೀರ? ಅಲ್ಲ ಇಲ್ಲೇ ಇಟ್ಬಿಡಿ ಈಗ, ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಬಂದು ಇನ್ನೊಂದ್ಸಲ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ತಿರ್ಲಿ. ಎಲ್ಲಿ ಬಿಡಿ ಸರ್. ಆಮೇಲೆ ಬಂದು
It is here live. That means it is on YouTube.
Yes, sir.
We should, by any chance, we should not come and make any submission. It is.
Serial number 71. Power to one.
New citation has been relied upon by Mr. Panana. Just one minute. Yes. 54 ಅಂದ್ರೆ ಕೆಳಗಡೆ ಇರುತ್ತೆ ಇದು. Loss? 1-3? Yes. B, G ಬರುತ್ತೆ 1-3 B ಇಲ್ಲ ಅಲ್ಲಿ. 1387 ಅಲ್ಲಿದೆ D. 88 ಅಲ್ಲಿ F G G ನ G. Yes.
This clause has to an extent to the petitioner can write or draw the court. But here the question is different. One is there is a finding inter partes that the scheme has not lapsed. Now the court says that finding has attained finality, right? So in our case also, finding has attained finality. There is probably another case where they say that the scheme has lapsed. So there are two judgments. One is saying that the scheme has lapsed, another saying that the scheme has not lapsed. In that situation, having regard to the fact position is already taken by the BDA, because they take a different complexion. Can you see section 48 of the United States Code?
Just one moment. Just one. Yes.
Except in the case provided for in section 36, government shall get liberty to withdraw from the any land of which possession has not been taken. And the rest of the issue. And section 16 also.
Yes.
When the collector has made an award under section 11, he may take possession of the land. It can thereupon the absolute government. So therefore, in a case where the land vests to the government, The question of revesting the same or revoking the vesting does not arise. This judgment is only an authority in a case where possession is not taken, and the court gives a writing that the scheme has lapsed and not otherwise. When there is a finding toward inter-parties, the market appeal. Court gives a finding right here.
How do you argue?
Even an erroneous decision, not a finding.
Only question to be considered is whether he may be entitled to take a benefit of a subsequent decision. That also you argued saying is not. Ms. Ponnana has argued that he is entitled. We'll have to consider that aspect. Third, reply arguments of the Ashokarani by senior counsel reserved. If done, and counsel for the petitioner submit that he has complied with all the subjection. Registry to verify. Released on 28/6. Interim order idea. Interim order earlier granted is extended next day. How much, Mr. Shanti?
I don't want one submission to make. That's not my page 18. The order of the reference court. Reference sent to this court under section 80 is allowed. Market value of the acquired land is enhanced 4 lakh per acre from 1 lakh 30,000 as awarded by the LA. Hence, the market value of 34 punta would be 3 lakh 40,000. That's the first one. The second one is that claimant is entitled for possession at 30% on the enhanced compensation on section 23, 2 of the LA Act, altogether with interest at 12% per annum from the date of notification till 16/3/1999. But it's very clear that 30% on the enhanced compensation should be paid, not on the interest. Not interest on 30%. This is the order of the reference. But therefore, when the execution court cannot go beyond.
Is that the stand that the central government wants to take? Is that the stand that the central government wants to take? In the morning you made a different submission. Now you are making a different submission.
It's there.
Very unfair.
Now I've got the calculation also.
Clearly, Muxi. I think, but matte yenano tegibadi.
No, I've got one more judgment where the execution court cannot go beyond the order of the reference court. That will not get it at page 51 of my compilation of that.
If you are making that submission, we'll deal with the submission. You'll have to deal with the submission. You are entitled to, but you are not a private litigant. We understand a private litigant can make all kinds of submissions because he is trying to do whatever he has to do. Being the state, even if there is some lacuna, it is for the state to show its big heart and come forward and say, if you don't have a big heart and you want to make that submission, please make the submission, then we will have to make a comment on it after. You can always advise your client as to what your client has to do and not to do. What we are saying is the court making an observation on that kind of a stand may not be good for the, but if you insist on it, then we'll have to make it. We won't shirk away from making it, but we leave the option to you.
The first point is that the execution court cannot go beyond the scope of the reference. The second one is that in the event, as per the Gurpreet Singh case, as I pointed out in the morning, in the event execution
1991.
1990-2001.
And 1990-2001.
In that event, I'm my submissions are there in the event. If the interest was there on solution, I'm liable to pay 41 lakhs. That is there. Because since the reference court has not said anything about the interest on solution, I want to make that submission.
Now what do you want to say? Reference court bidi. Now what do you want to say? Being the state, being the acquiring authority, do you want to come forward and give interest to the person for whom you are not paid the amount? Or you want to take the stand that I won't pay the interest? No further instructions. You make your submission. Your client will have to go by your submission and your advice. This is
Because the private particular, I would not have made that submission.
more so because it's a governmental authority. It has to go by what you say.
If you have 1,54,000 is excess pay, what the calculation?
ಇವಾಗ ಗೊತ್ತಾಯ್ತಾ ನಿಮ್ಗೆ ಯಾಕೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ತನ್ನಿ ಅಂತ ಹೇಳಿದ್ದು ಅಂತ. ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಪಾಪ ಅವ್ರಿಗೆ ಒಂದ್ ಪೈಸಾ ಕೊಡಲ್ಲ, ನೀವೇ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ ಅಷ್ಟೇ. ಆಮೇಲೆ ಅದಕ್ಕೆ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ತಗೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿ.
For our calculation, that the interest, that the event interest not be given. In that event, 144,000 is excess pay. In the interest, in the event, the interest is to be paid on the solution from 19 to 2000. But in that event, I have to pay 47 lakhs. This is my submission.
So now what do you want to do?
I take interest because he is also an interest officer. He has to get 100 from the not be kindly have it of 3 days. I will get instruction. Till then, not let us not consider the matter.
Don't press. You want the money or you don't want the money?
You want the money.
Then wait for 2 days.
They make a submission.
Let him get instructions. Let him make a submission. You are? Mr. Arun Govindaj accepts notice for respond number 1, 2, 3, Learned AG. Sri Nityananda Learned AG accepts notice for respond number 4. Sri Shanti Bhushan Learned Standing Assistant Solicitor General of India seeks for
He says that may be treated as after 15 days. He says. That he says 15 days I get it.
he says Allah.
That I will proceed to get it.
We'll have it on Monday. Monday, we will refrain from initiating.
The shortest possible date. But next week, 27th.
15 days ಅದ ಅಳಿಯ ಅಲ್ಲ ಮಗಳು ಗಂಡ ಅಂದಂಗೆ ಹೇಳ್ತಾರೆ. Let him get it. This is not the way that the central government seeks for and is granted a week's time to make a submission as regards whether the central government is willing to make payment of interest on the solution awarded or not. The submission of the learned counsel for the respondent that they would not precipitate the arrest warrant is placed on record. Released on 22/6 at 2:30 p.m. It will get uploaded at 2:30. It is not in your interest to precipitate. Please don't.
On record, I have to make my submission.
We had an inkling that this is what is going to happen. That is why we wanted the. That will be handed over. Yes. Yes, please. Who is trying to demolish what?
Property.
Hmm.
State highway.
Hmm.
So initially, the response number 3 started interfering. In the guise of road widening, they marked my property for demolition. Then I approached this one to court. Election F is the first order that is passed by this one to the court, saying that without notice, not to take any further action.
Has the land been acquired?
No notification. No notification for acquisition. Now, after this, again they marked the property for demolition. I approached this one to the court. Kindly see annexure M. The order passed by this one to the
Annexure
court.
page number.
Yes, no. Annexure and relevant portion is at page 54. Paragraph. In fact, this honorable court directed the commissioner's report to be filed. And after taking into consideration, these observations are made. Page 54, paragraph. Therefore, even if the report submitted to this honorable court is taken into consideration, the procedure to be followed, the respondent should be appropriately notify the petitioner about the endorsement.
So there's already an order restraining demolition in your favor.
There is an order restraining demolition. Immediately after that, they issue annexure N.
Annexure?
Saying that annexure N at page 56.
Yes.
Page 56. Last paragraph. You demolish on your own within 15 days. Without following the procedure not prescribed by this honorable court. Then again, I come before this honorable court. Annexure 3, there is an interim order.
So there is a fourth round.
This is the fourth round. Identical notice is again issued as similar to annexure F. The present notice is annexure yes, the earlier notices are filed. Annexure S is a present notice. Page number the right for copy at page 73. The last paragraph, the last quadrant of the page. They refer to the writ petition, all the 3 writ petitions and orders passed. And then they add one aspect saying Shitila Avasthani there. That is to say, if you don't demolish, when we demolish, if your entire house falls down, we are not responsible. About 5 or 6 lines from the bottom of the page. ಆದ್ದರಿಂದ ಈ ನೋಟಿಸ್ ತಲುಪಿದ 1 ತಿಂಗಳ ಒಳಗೆ ರಸ್ತೆಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡ ಕಟ್ಟಿಸುವ ಕಟ್ಟಡವನ್ನು ನೀವೇ ತಲುಪಡಿಸಬೇಕು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. ಕಟ್ಟಡವು ಶಿಥಿಲಾವಸ್ಥೆಯಲ್ಲಿರುವುದರಿಂದ ಇಲಾಖಾ ವತಿಯಿಂದ ರಸ್ತೆ
contention is that there is encroachment of public property. What is the remedy?
I am deciding there, I produce photographs, I am deciding there inside.
Dilapidated ಅಂದ್ರೇನು ಏನ್ ಮಾಡಬೇಕು? Which provision? What is to be done? Is dilapidated, so you demolish. Could that be a? Forget why they are saying. Even if they say that, what do they have to do? It is seen that there is a Learned AG accepts notice for respondent 1 to 5. It is seen that there is a 4th round of litigation. And in all the earlier petition, the petitioner had the benefit of an order restraining the respondents from demolishing the construction, the house constructed by the petitioner as described in the civil property. Hence, the respondents are restrained from demolishing any part, demolishing the house or any part thereof as described in civil property until the next date of hearing. When an AGS seeks for and is granted 2 weeks' time to obtain instructions and make his submissions or file his objections. Illa, you file your objection. When an AGA is directed to file his objections as also an affidavit of the author of annexure S as to how the said notice had been issued without reference to the earlier orders passed by this court. We left on PDM. We left on 27. Do this on 17.
For responding to also.
Any other neighbor to the marginal site and any application filed by them? No other neighbor. Yes. Do like 61,771. Two lakh 61,000 ಕೊಡಬೇಕಾಗಿತ್ತು.
Option price. Yes. As on that time, 2002, they have demanded 261,771. That at that point of time, mother-in-law petitioner is based on with regard to the value of the net part. It's not that that situation that went on 2007. But ultimately, PA has filed upon the mother-in-law petitioner to record it under 248,682. Can you see that page 22 and extra B? Page 76 is the relevant portion. I have produced the copy of the page 78.
Yes.
Here number 10. Now, engineering diagram ಕಡಿಮೆ ಮಾಡಲು ಪ್ರಾಧಿಕಾರ ಮಾಡಿದ ಅವಕಾಶ ಇರುವುದರಿಂದ ನಮಗೆ ತಿಳಿಸಲಾಗಿ ಅಂತಿಮ ಜಾಗದ ನಮಗೆ 2,48,682 ಪಾವತಿಸಿ ಇರುವುದು. That was the amount has been paid, but after annexure A page 87. In fact, the demand was question to the sample for ultimately we withdraw the requisition. Annexure A page 87 is the representation. Along with the representation, the demand draft. But for the sum of 248,682 was submitted on 19/11/2007.
This communication was in 2006.
It was in 2007. After this completion of this communication, the presentation, that the DPA sent an endorsement on 8/2008. Connection AB page 89. Stating that the site originally allotted by BDA for mother-in-law petitioner has been gifted to third party, and therefore she is not entitled for transfer. This is patently an erroneous endorsement because the gift was executed by mother-in-law petitioner, but in favor of her own son, which is okay for the husband of the petitioner here. By this endorsement was not communicated to the mother-in-law. And that the demand draft which was submitted in 2007 that continued to be within the BDA till 2019. So after the death of his mother and after the husband of the petitioner, when she started for execution of husband selling the original that has been done in 2019. At that point of time, right, the petitioner realized that the demand draft submitted in 2007 has not been realized by the BDA. And the process with regard to the allotment of marginal part is not yet completed. Then the petitioner submitted a representation. Page 104. requesting for return of the demand draft submitted in 2007 for the purpose of publishing the fresh demand draft. That pursuant to which the demand draft was returned. And the petitioner had once again submitted another demand draft for the same amount on 28/2/2020 and actual page date is 196. Page 191 is copied the demand draft. And now I am requesting the VDA to complete the allotment of marginal plot within 28 square meters. It is less than the minimum flat in the area of 6 and the amount which was calculated in 2002 was the average action price of the site. But now the contention of the VA is that this 28 square meter is a separate corner site, therefore it has to be auctioned and it can't be moved. That is only different matter of the VA. And to know the matter,
ನೀವು 30,000ಕ್ಕೆ ಜಗಳ ಮಾಡ್ಕೊಂಡು ಇಷ್ಟು
it is because of that reason that it had to
remove the wood for the piece. Yes, Mr. Kiran.
For any allotment of corner site, rule 5 of the VDA disposal of corner site rules 1984, your lordship.
You have to auction it antira.
Rule 5.
Corner site. Corner site.
Yes, sir.
It is a corner site.
It's a corner site, your lordship. Your lordship.
How is it a
Please
corner
look into
site, Mr. Kiran?
Lordship.
How is it corner site? What is the measurement?
Lordship, it is
next 15 is the first sketch of the
sketch illela ittalla. Page 38 ನೋಡಿ. ಒಂದ್ ಕಡೆ ಅಂತೂ 0, ಇನ್ನ ಒಂದ್ ಕಡೆ 4 meters.
4.6 meters and 12.50 meters.
10 feet is this one. Do you think anybody will buy it in auction? And are you serious about contending that it's a corner site?
Annexure R1 may be looked, your lordship, because the site number has been assigned to it.
You have allotted a site number for this?
Yes, sir. Annexure R1, your lordship.
R1.
Site number 2358.
When did you allot the site number, Mr. Kiran?
Lordship, the date is not reflected in this. And this is the document which was available in the file.
Then why did you collect the money? Why did you collect the demand draft? Why did you raise a demand? Why was it in litigation before this court?
Lordship,
why did you reduce the amount?
No, 2002 we have demanded a particular amount, but they did not pay at that time, your lordship. They paid only in 2007.
At that time it was not a corner site. Now it has become a corner site.
No, even the corner site, because of the area, probably the authority has thought that it is better to allot to the.
Yes. Now what year rules are you referring to? 1984. You want to refer to 1984 rules after having done all these things in 2002. Authority should not be doing all these things. Don't put people to trouble. Instructions are you're instructed to submit that.
Even the allotment can happen even now, but it is at the current market rate, your lordship. They cannot demand the 2002 price, your lordship.
Yes.
Because lordship, annexure R3, your lordship, there is a STF report wherein the petitioner have encroached on this illegal, your lordship, and they became a illegal occupant
They
of
were
this
under
land,
the
your
impression that you will do the sale deed after having collected the money. You don't permit the demand draft in your account. What to do?
No, much prior to that, they have constructed the house, your lordship. That is what the annexure R3 says, your lordship.
ಆವಾಗ ನೀವೇನು ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ, ಇವಾಗ ಹೇಳಿದ್ರೆ ನೀವು.
And moreover, your lordship, she was the lessee. The petitioner was the lessee till 2019. The sale deed, she became the owner for the allotment.
Yes.
As per to rule 5. It's only in 2019 they got the sale deed, Your Lordship.
So,
Because the rule clearly says,
so what difference does that make?
now till the sale deed is executed, she could not have, as per the allotment of the Karnataka site, Your Lordship. That is the understanding.
No, you are making allegation against petitioner. What about your officers, Mr. Kiran? Why did you raise the demand and collect the demand draft?
Now 2002 we have raised, Your Lordship, but they are not paid at that time.
Was there a sale deed at that time?
No, Your Lordship.
Then why are you raising that question now? The more you are making this kind of submission, it appears that your endorsement is mala fide. There is nothing bona fide about your endorsement. The submission made by you lead to the only conclusion that is mala fide. Why should we not impose costs on your authority?
No, Your Lordship. The authority is still willing, Your Lordship, recently. But the only thing is
That
they have
should
to
be
pay
the
the
fair
current market.
submission. Fair submission would have been, yes, we made a mistake. We did not remit the demand draft. Give us 2 weeks time. We'll do it. Anta bandi helbeku.
If they have paid it in 2002, they would have been allotted, Your Lordship. But 2007 they have paid it. It has to be the present market value, whatever on the date they pay, the allotment date, Your Lordship.
Now we will ask your officers to pay the present market value as cost on this. That is the conduct of your officers.
No, Your Lordship. If
The
the
petitioner is before this court seeking for the following reliefs. The petitioner, the mother-in-law of the petitioner, number 1 and grandmother of petition number 2 and 3 were allotted a site number 2357 measuring 25 feet by 40 feet at HAS second stage Bangalore on 25/8/1988 and were put in possession thereof on 9/11/1988 with the Tata being effected in their name on 12/4/1988. On an application being made for a building license was granted on 9/9/1998 and construction was put up on the said site. Realizing that there is a marginal land situate on the which side?
Northern side, Your Lordship.
On the northern side of the said site, measuring in all about 30.25 square meters, which is less than 1/3 of the site area of the site allotted to the, what is the name of the mother-in-law? Site allotted to Srimati Lakshmama. She applied for allotment of marginal land on 7/7/2001, as regards which an endorsement came to be issued. 2001 Allah. You applied when? Because the first demand was made on 29/7/2000. Your application has to be prior to that. See your para 7, Annexure H. First demand was made on 29/7/2000. So your application was prior to that. Made an application to the BDA for allotment of the marginal land, in persons of which on 29/7/2000 the demand was raised by the BDA for payment of an amount of rupees 2,95,028. Hence the petitioner submitted a representation on 7/7/2001 seeking for reduction of the value considering that it's marginal land. Considering the said representation, the respondent BDA reduced the amount to rupees 2,61,771, while his demand notice dated 20 March 2002. Thereafter, there are several correspondences which were exchanged between the said Lakshmamma and the BDA, seeking for reduction of the amount. In the meanwhile, the said Lakshmamma, being of advanced age, had executed a gift deed in respect of the said property in favor of her son on 23/4/2005. On 9/11/2005, on 26/7/2006, the VDA issued an endorsement calling upon the said Lakshmamma to make payment of a sum of ₹2,48,682, which was challenged before this court in WP number 2441 of 2007, which came to be disposed of with a direction to the respondent to consider the representation of the petitioner. The representation was considered, and in the year 2007, on 29/3/2007, a report from the VDA was received as regards the valuation. Thereafter, the said Lakshmamma made payment of a sum of ₹2,48,682 by demand draft bearing number 051932 dated 19/11/2007, drawn on State Bank of Mysore, Ambedkar VD branch, along with which was along with representation dated 19/11/2007, which was acknowledged to have been received by the respondent. Thereafter, by the BDA. Thereafter, no action was taken by the BDA. In the meanwhile, the said Lakshmamma expired. The lease cum sale period as regards site number 2357 has come to an end. The petitioners had approached the respondent to execute a sale deed, which was so done on 5/7/2019. Realizing that the marginal land was not covered under the said sale deed, the petitioners once again approached the VDA, seeking for transfer of the marginal land which had been allotted in their favor. It is in reply thereto that the respondent BDA has issued the impugned endorsement dated 18/1/2000, dated 28/2.
Point of time, if the demand draft itself is not realized, then we might.
No, where is that? This one that because there's a gift deed. You just read it first. Page 89. It is only then that a copy of the endorsement dated 18/1/2008 was handed over to the petitioners. Stating that since gift deed had already been executed, the marginal land could not be transferred to the said Lakshmamma and or the petitioners. Though the said endorsement was handed over, it is not in dispute that the demand draft continued to be in possession of the BDA. It is in the above background that Sri Vivekananda, T.P. Vivekananda, learned counsel for the petitioner, would submit that the respondent having raised a demand of rupees 2,48,682 and the said amount having been paid by the said Lakshmama, it was the duty of the BDA to have executed a sale deed, allotted and executed a sale deed in respect of the marginal land. The gift which has been executed is by Lakshmama in favor of her son, which is not a transfer which could disentitle the allotment of a marginal land. Be that as it may, the allotment of marginal land is as regards, be that as it may, the marginal land has been allotted. The only duty to be performed by BDA was the execution of sale deed. In reply, Sri C.V. Kiran, learned counsel for the respondent BDA, would submit that the land in question is not a marginal land, but is an independent site bearing number 2358, and therefore the same cannot be allotted to the petitioners and or a sale deed executed. Secondly, he contends that a gift deed having been executed by the applicant, the question of execution of a question of allotment and or execution of sale deed in favor of the donee of the land would not arise. Thirdly, it is contended that the independent site number 2358 being a corner site, the only manner in which the said corner site can be disposed of is in terms of Rule 5 of the BDA corner sites.
Disposal of corner sites, Rule 1984, Your Worship.
The BDA bracket disposal of corner sites and commercial sites bracket close, Rules 1984. And as such, he submits that such disposal can only be by way of an auction and not by way of an allotment. Any other contention, Mr. Kiran?
Your Lordship, if the petitioner is still willing to pay the current market price, the BDA is willing to allot, Your Lordship.
Lastly, he submits that if the petitioner is willing to pay the current market price, the respondent is willing to. You want to make that submission? Contradictory submission. The BDA will allot the said land and execute its sale deed. Upon instructions, he submits that. Third, Sri T.P. Vivekananda, learned counsel for the petitioner, Sri C.V. Kiran, learned counsel for respondent 1 and 2. It is not in dispute that the land abutting site number 2357 in all measures 26.84 square meters. Where is Jagal Bear?
30.25 square meters.
30.25 and 30 and now Jagal 26.
After submission of the demand draft, he mentioned
AL. What is it? 26.04 square meters.
This is prepared on 8/1/2020.
G, Your Lordship, it says 30.25 square meters.
The rule of the sketch which has been prepared on 8/1/2021 indicates that on the eastern side, the measurement of the side from south to north is 0.25 meters. On the western side, it is 3.95 meters. On the southern side, from east to west, it measures 12.40 meters. And on the northern side, it measures 13.30 meters. In view of the same, whereas the site of the petitioner measures 25 meters, 25 feet, 25 feet by 40 feet. So also is the similar measurement for site number 2356. Taking into consideration the sketch which has been prepared by the BDA itself, I am of the considered opinion that the area which, as regards the petitioner had applied for, could never have been shown as a site, as a separate site, nor can it be classified as a corner site. I am reinforced by this view by the very actions of the BDA, inasmuch as from the year 2002 to 2008, the BDA has considered the various representations made by the said Lakshmamma, agreed to allot the said area on payment of certain amounts. The only issue was as regards the consideration liable to be paid for this marginal land. From the year 2002 to 2008, at no point of time the BDA contended that the said marginal land is a separate site by itself, and or the same would be governed by the Bangalore BDA Disposal of Corner Sites and Commercial Sites Rules, 1984. In fact, the BDA went on to value the said land and called upon the said Lakshmamma to make payment of the amounts due thereon. Thus, the contention now raised by the BDA that this land cannot be allotted because it is governed by the rules of 1984 is completely misconceived and, in my considered opinion, completely malafide and is therefore rejected. As regards the contention that there is a gift which has been executed by Lakshmamma in favor of her son, therefore there being a transfer, there won't be an entitlement for allotment of a marginal land, is again completely misconceived. Firstly, the gift deed has been executed by a mother in favor of her son and the petitioners, who are all immediate family members. The gift of the site number 2357 made in such a manner cannot amount to be a transfer to a third party, the transfer being within the immediate family members. Be that as it may, I am of the considered opinion that allotment of a marginal land is not as regards a person, but is as regards the site abutting the marginal land. The marginal land being to the benefit of the owner of the site, whoever the owner may be, whether it was Lakshmamma or the petitioners now. The mere execution of a gift deed would not, in my considered opinion, make any difference as regards the allotment having agreed to be made by the BDA way back in the year 2002 on collection of the market value, on collection of the amounts which were tabulated as on that date on the auction amounts for similarly situated land, and as such being the market value of that land. Hence, this contention raised at this related period of time is also rejected. The last contention being that there is no action taken by the petitioners, and therefore the petitioners are now required to make payment of the market value of the land as on today, and it is only then that the BDA would allot the marginal land and execute a sale deed, is again completely malafide. It is clear from the records that the petitioners had submitted a demand draft way back in the year 2007, a copy of which has been produced at Annexure AJ, which indicates that the demand draft is dated, the banker's check, banker's check is dated 12/2/2020. Banker's check dated 19/11/2007, drawn on State Bank of Mysore, Ambedkar VD branch, Bangalore, for an amount of rupees 2,48,682. It need not, it is it need not be said that the banker's check would be only issued on payment of the amounts covered under the banker's check. Therefore, the said amount of rupees 2,48,682 had been paid by the petitioners to the bank for the purpose of issuance of the banker's check. The receipt of the banker's check by the BDA is also not in dispute and continued to be in possession of the BDA till the year 2019. The BDA, the petitioner had lost the benefit of the amount covered under the said banker's check as soon as the banker's check was drawn, and the said amount continued to be in possession of the BDA till the year 2019, when the BDA has refused to allot the marginal land and execute the sale deed. Thus, the contention now being advanced that current market value has to be paid is again completely misconceived. The petitioner cannot be held liable for the defaults on part of the respondent officials who did not encash the banker's check and do the needful, and or if they are not agreeable, return the same to the petitioners and or Lakshmama. Correct. There's all the contentions which have been advanced by the respondents being completely mollified and raised only to deprive the petitioners of the allotment which had been made by the respondents by picking and choosing certain contentions only to frustrate the claims of the petitioner, which is not permissible under law. I have the considered opinion that there is a cost which needs to be imposed on the BDA for these kind of frivolous litigations. And as such, I deem it fit to award compensation at ಎಷ್ಟು zero, Mr. Kiran?
I request your lordship, I pray. No
The
such
market
cost be-
value ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಅಷ್ಟು ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂನೇ ಹಾಕೋಣ.
Lordship, I pray your lordship. I literally beg your lordship to pardon the officials.
Please don't beg. Please don't beg. Please make your submissions. Please don't do that. You are a counsel. Please don't do that. The sum of rupees 1 lakh has passed. Hence, I pass the following order. Writ petition is allowed. The respondents are directed to a certiorari is issued. The endorsement dated 18/1/2008, which had never been communicated to the petitioner at annexure AB, is hereby quashed. A mandamus is issued to the respondent to consider the representation dated 28/2/2020 at annexure AJ submitted by the petitioners and execute a sale deed in respect of the marginal land measuring 26.04 square meters within a period of
8 weeks, your lordship.
8 weeks from the date of receipt of a copy of this order. Counsel for the petitioner is permitted to furnish a copy of this order on the respondent. The respondent shall act on a printout of the uploaded copy of this order without insisting on a certified copy. If there be any doubt, the respondent would be at liberty to contact its counsel and or verify the same from the website of this court. The petitioner, before the last table, the petitioner had submitted a demand draft dated banker's check at annexure AJ. If the same has not been encashed by the BDA, the petitioner to remit the said amount within a period of 1 week from today upon the return of the said banker's check. Don't wait for it, just go give it. ಇನ್ನೊಂದು 10 ವರ್ಷ ಹಿಂಗೆ 25. None appears if none were to appear on the next date of hearing, petition will be liable to dismiss for non-prosecution. Previous from 28/6. So ready?
I appear for the petitioner.
Mr. Murli.
Let the petitioner applied for site flood allotment of site on 1/11/2015 at Nada Prabhu Kempegoda layout. Thereafter, the site was allotted on 11/10/2018 at Annexure A. 2018. Since that site was not allotted in a convenient place, and some disturbance was there he submitted another application for allotment of alternative site. Annexure B, alternative site was allotted on 3/6/2019. And immediately next day I deposited the entire amount, Annexure C. Income tax. Yes, they have requested to furnish all the original allotment letters, original first allotment letters, everything. I have submitted Annexure D for registration of the execution of the sale deed on 7/6/2019. In spite of the same, they have not executed. Then Annexure E, show cause notice was issued, saying that I have not deposited the entire amount within 60 days from the date of allotment, first allotment.
Yes.
And wanted to forfeit the amount as per Rule 13(1), for which I have submitted representation Annexure F.
Saying that you have remitted it immediately on the next day.
Next date,
yes.
Another representation also Annexure G I have submitted, page 21.
Yes, Mr. Murli. Michael Makal, ready or first. Michael.
11/10/2018. We asked to deposit the entire amount within 90 days from the date of order. Without depositing amount, we made a request for alternative. Same was considered reallotment of next. It is not new allotment. It is an alternative to first allotment.
You will forfeit the entire amount and cancel. Then you will forfeit the entire amount and cancel because there is a delay. Then why did you allot the alternate site? Because the delay was in the first site. Alternate site input. The document that is 2020.
Immediately after receiving that. There is a delay in payment.
He has said he has paid it in full. If there is any interest, I will pay. Nimatra Sikakunda Yenu Madakagala Jana. And instead of discharging public functions, you think you can do whatever you want. Yes. All this you are making submission after giving the alternates. You could have done it before, if at all there was. The fact that you are given an alternate site is, there's no delay. We will start imposing costs in all matters. If this is the BDS conduct. Statutory authority, if you make a mistake, everybody makes a mistake. Mistake ಆಗಿದೆ ಆಯ್ತು will do it ಅಂತ ಬಂದು ಹೇಳೋದು. You take action against those actions. The petitioner is before this court seeking for the following reviews. The petitioner had submitted application for allotment of site on 28/5/2004, 31/12/2015, and 1/2/2018 in pursuance of various notifications issued by the BDA from time to time. It is in pursuit of the third attempt that the petition was allotted a site measuring 15 into 24 meters on 11/10/2018 in the Nadaprabhu Kempegowda layout formed by the BDA. There being certain issues in respect of the site which had been allotted, the petitioner made a request for allotment of the alternate site, which also came to be allotted on
3/6/2019, Annexure B.
3/6/2019. And the petitioner was called upon to make payment of the amount of rupees
83,87,000. Annexure C.
Annexure C ನಲ್ಲಿ ಡಿಮ್ಯಾಂಡ್ ಎಷ್ಟಿದೆ?
ಇದರಲ್ಲಿ Annexure A ಇದೆ ಸರ್.
54 lakhs ಇದೆ ಅಲ್ಲ ಮಿಸ್ಟರ್?
Totally 96,87,510.
ನೀವು ಪಾವತಿ ಮಾಡಿರೋದು 12 ಲಕ್ಷ, ನೀವು ಬಾಕಿ ಇರೋದು 84 ಲಕ್ಷ.
ಹೌದು.
ನೀವು ಶಾರ್ಟ್ ಫಾಲ್ ಇದೆ ನಿಮ್ಮಲ್ಲಿ.
ಅಲ್ಲ 5,000 ಇದು ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ಗೂ ಕಟ್ಟಿದೀವಿ.
84,79,000 is the demand. You have made payment of 83,87,000. So ಒಂದು 70,000 ಏನೋ ಡಿಫರೆನ್ಸ್ ಇದೆ.
ಇದ್ರೆ I will pay that.
Demand of 84,79,010. Pursuant thereto, the petitioner remitted an amount of rupees 83,87,135 on 4/6/2019 and was awaiting the execution of the lease cum sale agreement. As regards the same, the petitioner also submitted all the documents under cover of his letter dated 7/6/2019, which was received by the respondents. However, by letter dated 18/8/2020, it was contended that there was a delay in payment of the amounts, and as such, the respondent contended that the allotment would be cancelled and the amount deposited would be forfeited, which was replied to by the petitioner on 27/8/2020, giving the details of the payment made. Thereafter, no action has been taken by the respondent, and as such, the petitioner is before this court seeking for the aforesaid relief. Shri Nanja Reddy, the counsel appearing for the petitioner, would submit that if there is any balance of amounts, the petitioner would make payment of the same if a demand for the same is raised or if the information is furnished. The petitioner has submitted, has deposited
balance allotment price.
Balance allotment price. The petitioner has deposited all substantial amount of the allotment price, and the respondent cannot delay the execution and registration of sale deed in favor of the petitioner. Shri N. Murli, learned counsel for the respondent, would submit that the present allotment made on 3/6
2019.
19 is an alternative site. There is a delay on part of the petitioner in remitting the amount towards the earlier site which was allotted. Therefore, there being a delay, the respondent would be well within his right in terms of Rule 13 of the BDA allotment of site rules 19. 13.1.
1984.
BDA allotment of sites.
84.
Land Development Authority allotment of site rules 1984. And as such, the petitioner, the respondent is entitled to forfeit, cancel the allotment and forfeit the entire amount. Correct. Heard so on, so on. The only contention of the respondent is that there being a delay in payment of the money towards the earlier allotment, even subsequent to the allotment of the alternate site, the amount deposited could be forfeited. And they consider view that the said contention on part of the BDA is completely malified. Once the BDA is allotted the alternate site in lieu of the earlier site which is not proper and or suitable, the mistake having occurred on account of the BDA cannot take advantage of the same now. Having issued an allotment letter dated 3/6/2019, indicating the amount which is due, the BDA can only claim the said amounts and not try and frustrate the claim of a allottee like the petitioner in getting a sale deed executed as regard the site allotted to the petitioner. The contention of the BDA being completely malified, I am the considered opinion that costs are to be imposed and as such are quantified at rupees 50,000 to be payable to the petitioner. In view thereof, I pass the following order. Writ petition is allowed. The mandamus is issued directing the respondent to execute a sale deed in respect of site bearing number B5SG5945 as contained in the allotment letter 3/6/2019 by collecting any balance amounts due.
Balance title value.
Balance allotment value due, as also the registration fee and stamp duty payable on the said sale deed within a period of 12 weeks from today.
Yes.
Copy of the order.
Published.
Has to be paid within a period of 3 weeks. You gave it on time, and you are at fault. The District Learning Council submit that a 6 point is granted 2 weeks time to file a statement of objection. Objections returning to be filed on or before 28, on or before 30/6/2022, released on 5/7. None appears for the petitioners today also, nor are the copies furnished to the respondent. If none were to appear for the petition on the next date of hearing, the petition would be dismissed for non-participation. Released on 28/6. Objection file ಮಾಡಿದಿರಾ? Respond number 3 actually. Objections ಆಗ್ಬೇಕಾ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ಯಾವಾಗ? Ajay Kumar, learned counsel for the BDS, submit that the matter has been referred to the Anti-Corruption Bureau for inquiry on account of fraudulent sales which have been executed. As such, he seeks for and is granted 6 weeks time to file a statement of objection. Statement of objection is continued to be filed on or before 15/7/2022, released on 19/7. Copies the world. You just have to make an application to them and
The petitioner, Your Honor.
you are appearing. Ajay Kumar has entered appearance, registry delayed name of Sri Gopal V. Bilamani as that appearance to respond. Objections? Well, this was connected to that other matter. Morning you made some submission. So this is connected to that matter.
In a way, but this is not a matter where site was allotted in the place where ozone exists. Ozone doesn't exist. That's all it is.
ಏನಾಯ್ತು ಇಲ್ಲಿ?
Redo scheme ಹೋಗಿ. Redo scheme
It's also connected to that. 50 connect to serial number. What is it? Serial number 14 and released on 14th order 21/6. K. Krishna has entered appearance for R1 and R2, delete name of Murgesh Charati as that appearance.
And according to that, I have appeared and participated in the auction and on annexure A for confirmation of allotment issue. Annexure A in the
ಏನ annexure ಹೇಳೋ ಪೇಜ್ ನಂಬರ್ ಹೇಳ್ಬಿಡಿ.
page 80 annexure A. Auction advice letter has been issued.
Yes.
On 28/9/2020, according to that, I have paid a payment of 30,27,220.
ಯಾವಾಗ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರಿ?
That is around 25% of the auction amount. That is total amount of auction is 52,09,280. Total site value.
You are required to pay how much when, Mr. Required? Remit 25% of the time, excluding
Yes.
so and so, on or before 110.
110.
That is 9,27,000. So you deposited that within 110,
I have
210.
25 lakhs, not that, 30 lakhs that I have deposited.
110 ಬದಲು 210 ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ.
ಆಮೇಲೆ ಏನಾಗಿದೆ? Subsequently that I have given a representation. The annexed since confirmation letter has been given to me.
Yes.
And be directed to pay remaining amount. Then there are
ಎಷ್ಟು ಇದೆ ರಿಮೈನಿಂಗ್ ಅಮೌಂಟ್?
remaining amount 39 lakhs.
ಎಲ್ಲಿದೆ?
Remaining amount.
ಎಷ್ಟು ಅಮೌಂಟ್? When was it?
39 lakh 42,140.
When was it to be paid?
This is around 16/10/2020 without confirmation letter issued. Then around I have paid 20 lakhs.
When was it 39 lakhs to be paid as per this letter, Mr.
Within 45
Within 45 days of 16/10. When did you deposit 20 lakhs?
On 5th July 2021, 3/7/2021.
So that is after 9
Yes.
months.
Yes.
And not even the full amount.
I told you that. But then on annexure E 26, 20 lakhs and letter has been issued.
Yes.
And on 5/7/2021. And then remaining amount of 19 lakh 42,140
has been paid a lot on 8/9/2021. In the meanwhile, I have given a representation. Not annexed the 2028. Because in the year of 2020, COVID crisis was there, that's why I did not pay. Therefore, I have requested to extend time for payment of
You participated in the auction during COVID time. It did not prevent you from participating during COVID time. Payment matra it prevents you.
Under the COVID period. As of the date of cancellation.
Same thing that applies to BDA applies to the petitioner also. You have to come clean.
I fully agree.
Don't make
I have
those
paid not the entire amount. Whatever interest that they are claiming, I can ready to pay. If reasonable, the cost imposed because your lordship dealt prior to matter, saying that imposing cost because they are not users. They are into saving of sites and allotment.
That was where the petitioner was clean. You are dirty here.
I am 64 years old. And
age Allah now. It's not age Allah. You are giving all stories. COVID time or Adela. Why should you?
But we as of date, entire amount has been paid. And in case they are claiming interest on the amount delay, and in case if you are also to some cost for delay, also I am ready to pay because now they are forfeiting my amount. And because at the age of 64, I have obtained loan for constructing a house. This is not for the other purpose. Therefore, it was auctioned as per the this was video, this was on corner side and commercial side. 263 it says that the auction was conducted in between 28 and 10/9/2022, 29/5/2022.
The date of auction and final date. E-auction, last date. 28/9/2020. Confirmed on 28/9. 16/10/2020.
25% is deposit with the month 2010. 20 is the last
1 day extra.
Remaining amount he has to deposit within 45 days from the confirmation of payment. Here they are not deposited. Now 20 lakhs amount was deposited on 5/7/2021.
He did not approach for extension of time during that time.
No, he has not made the extension time. In spite of that, we have.
Did you cancel during that time?
We have cancelled. But we have before that, we have also thought of an issue notice as an R1 to my statement of objection.
Yes.
This is the 5/10/2010 we have received written letter. The deposit of the 25% of the now completed.
But wait for him. Out later, Mindalai.
ವಿಳಂಬದ ಅವಧಿಗೆ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಮುಂದೆ ಅಂತೆ ಶೇಕಡ 18 ಮತ್ತು 21% ಬಡ್ಡಿಯನ್ನು ಪಾವತಿಸಬೇಕಾಗಿದೆ. ಅದರಂತೆ ನಿವೇಶನ ಶೇಕಡ 25% ಮೌಲ್ಯವನ್ನು ಪಾವತಿಸಲು ಬಡ್ಡಿ ರಹಿತ ಅವಧಿ 45 ದಿವಸಗಳು ದಿನಾಂಕ 6/12/2020 ಕೊನೆಗೊಂಡಿದ್ದು ದಿನಾಂಕ 7/12/2020ರಿಂದ 90 ದಿವಸಗಳ ವಿಳಂಬದ ಅವಧಿಗೆ ಶೇಕಡ 18% ಬಡ್ಡಿ ಪ್ಲಸ್ ದಂಡ ಮತ್ತು ದಿನಾಂಕ 7/3/2021ರಿಂದ 320 ದಿವಸಗಳ ವಿಳಂಬದ ಅವಧಿಗೆ ಶೇಕಡ 20% ಬಡ್ಡಿ ಸೇರಿಸಿ ಪಾವತಿಸಬೇಕಾಗಿದೆ. ದಿನಾಂಕ 5/7/21 ಬಾಕಿ ಮೊತ್ತದ ಪಾವತಿಸಲು ವಿಫಲರಾದಲ್ಲಿ ನಿವೇಶನದ ಶೇಕಡ 25% ಮೊತ್ತವನ್ನು ಯಾವುದೇ ಮುನ್ಸೂಚನೆ ನೀಡದೆ ಮುತ್ತು ಹಾಕಿಕೊಳ್ಳಲಾಗುವುದು. ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. ಇದು ಅಂತಿಮ ನೋಟಿಸ್ ಎಂದು ತಿಳಿಯುವುದು. July 15/9/2021. They cancelled on 17/8/2021. 17/8/2021. It was cancelled and forfeited as per Rule 63. Then we have
after the cancellation, the balance has been remitted.
balance amount, now the account past the account number will return the amount. And
That should be. That is something.
Let him complete. Any other submission?
Because the completed the, this was confirmed by 60 is confirmed by this region, we have the people. Completed the amount, if they are not paid the amount within the 45 days. That's what confirmed by the region.
Anything else?
The reason of the delay here is not the reason and the chicken is not correct, because the auction itself is conducted after the COVID period. And he was well aware of that the equation was the auction was conducted under this rule and 45 days and the maximum period permitted. And we have also issued a no objection certificate to the petition on the day we have deposited 25% to avoid the bank itself.
But please come clean. If you make these kind of submissions that you made a little while back, one who comes for discretionary review has to come clean.
I have given represented that is what COVID it's I have stated in my presentation. Since COVID effect is not that only lockdown that runs about 2-3 years so far as crisis is concerned, that is that context I have
yes.
Election accordingly, 20 lakhs has been paid from July 2022.
Yes.
And we have no representations in that to grant election. That 20 lakh has been accepted. Thereafter,
that will be accepted when it is gone. Any amount can be deposited anywhere. ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಅಲ್ಲಿ ನೀವು ಇವಾಗ ಹೋಗ್ಬಿಟ್ಟು ಏನಾದ್ರು ಡೆಪಾಸಿಟ್ ಮಾಡಿ ತಗೊಂತಾರೆ. ಅವ್ರೇನು ಇಲ್ಲ ಅನ್ನೋರು ಯಾರು ಇಲ್ಲ ಅಲ್ಲಿ. Because they won't know who is receiving for what. Please don't.
And that we have as on we have stated clearly that this cancellation order on the receiver of 9 and we went to payment of the amount. That the last amount has been paid in that 12. Clearly stated that that amount has been received. That once we have added over the cancellation order. Immediately we have approved this on this honorable court was pleased to grant it. My instruction submission is any minimum cost and whatever fine and interest on the amount which is delayed, whatever your lordship directs and because otherwise I lose site as well as the cancellation order taken.
You are trying to overreach this court and overreach the BDM, Mr. Bhatt. You are trying to overreach the court and also the BDM. After cancellation, you go and deposit, and you now say that you are deposited and you want to.
Your lordship can impose cost if they have produced that cancellation what is served.
When was it served?
As per my instruction, that they have clearly stated that this cancellation order has not served. Therefore, we have deposited and that point of time will be articulated. That is the parameter we have.
You received 17.8. 17.8 you have received. You have received 17.821, Mr.
this 17/8/2021 order received the Lord at the time of payment of last amount of 17 lakhs.
In spite of which you went and paid the money.
Yes, sir.
In spite of which you went and paid the money.
So, 8/9/2021, Lord, after payment of 19,42,140, we have received this cancellation order. Then we have requested, but they have said no. And therefore we have approved this one. That is what we have stated in my paragraph.
Yes, Mr. Chifa. When was it received? 17/8 and 9/9 both. 17/8/2021
September
and
2021
12/1/2021. R2, Annex H and R2. When was it received by the petitioner?
It was received by him on 18/9/2021. But the rule says that the notice is also not required.
Notice not required bere. Your 17/8, when was it received by him? Annex H. Receipt problem illa, date problem illa. Because they are produced along with the petition. Date for what? Rule will come to later. Facts bande tane rule baradu. Without facts, how do we apply the rule? Your notice is in January and 17/8 you are cancelled. If the cancellation is order has been given to him after he makes payment. 9/9.
He paid the second installment on I think 9/2000.
So a 13/9 you put after receiving the money, and then you want to forfeit, then it will be modified on your part.
I specifically stated that we have not received voluntarily that we have not given the permission of channel.
Correct, they deposited. But is it after the deposit or before the deposit that you issued 17/8? Because the date is crucial. ನೀವು ಆಮೇಲೆ ಕೊಟ್ಟರೆ ನಿಮ್ದು ಮಾಡಿಫೈಡ್, ಇವ್ರು ಆಮೇಲೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಮಾಡಿಫೈಡ್.
5/7/2021 ಅವರು ಲಾಸ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟು ಅವತ್ತು 20 ಲಕ್ಷ ಕೊಟ್ಟು ನಾನು ಅಲೆಕ್ಷನ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ. That is the last third paragraph.
5/7/2020. But the interest ಎಲ್ಲ calculate ಆಗಿದೆಯಾ? Did you pay all that interest?
Yes, sir. Whatever the calculations they have given. Now we admit that he has received this letter.
R2 he has received. There is no dispute. No, the issue is only on 17/8, Mr. Annex H. Where ella is received. Only Annex H he refused. And that is a crucial document. So you let us know when it has been given. When it's been received by him, not given up. After arguing for some time, Shri K. Krishna learned counsel for respond number 1 and 2. Seeks for and is granted a week's time to make a submission as to when Annex H has been served on the petitioner and received by the petitioner. Released on 21/6. Obviously. With written proof, oral submission. 52.
Lords, I appear for the respondent, my lords.
Yes.
Last evening, the copies were served on me, my lords. I seek some
Yes, sir, Mr.
accommodation.
Vasant Kumar. Why you served it last evening?
I was
You take 15 days to serve under AMA. Shri Ram Prasad, Learned Counsel, for respondent number 1 and 2, submit that you have served with a copy of the petition only last evening. He seeks for and is granted 3 weeks' time to obtain instruction and file his statement of objections. Objections, if any, to be filed on or before 7/7/2022, released on 12/7/2022.
Obliged, obliged.
Kiran? Cell number 53, Mr. Kiran, please unmute yourself.
I appear for your respondent BDA, Your Lordship.
Yes, Mr. Kiran, objections in Akila.
Akila, Your
Lordship.
And that's 2 weeks' time may be granted, Your Lordship.
ಇವತ್ತು ಕೊಡ್ತೀವಿ ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ ಯಾವ್ದಲ್ಲೂ ಕೇಳಬೇಡಿ ಪ್ಲೀಸ್ ಆಲ್ ಮೀಡಿಯಾ ಕೌನ್ಸಿಲ್ಸ್ ಪ್ಲೀಸ್ ಡೋಂಟ್ ಆಸ್ಕ್ ಫಾರ್ ಟೈಮ್
Much obliged, Your Lordship.
Next week if you ask for minimum 5,000 rupees.
Because
you find a good cause. Site owners agreed by Arkavati layout our deposit ಮಾಡಿ. CV Kiran seeks for and is granted 2 weeks time to file a statement of objection. Objection is only be filed on or before 30th, released on 5/7.
Much obliged, Your Lordship.
Yes, Mr. Arvi. Sadashivaya.
That's for respondent number 3 and 4, my lord. My lord, senior left the office at 2, my lord, on an emergency call, my lords. Kindly have it next day, my lord.
Emergency. Name the objection.
Now they are seeking representation to allot a marginal. Now see, in the petition itself says that his right was auctioned by the land and they purchased by third party. The site is not a marginal land, it is seeking for marginal, not to give the any marginal.
Nim locus and one.
That is the subject matter. In the WP number will not still for 1/4 of the WP.
ಅದು ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ. ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಆಪ್ಷನ್?
Is the interesting party in that which is not. The three purchase day represent challenging the order of the DRT.
ಅದು ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ if you succeed.
Then it is keep repeating the
ಏನು?
this question also.
ಏನು ಪೆಂಡಿಂಗ್ ಏನಕ್ಕೆ ಇಡ್ಬೇಕು ಮಿಸ್ಟರ್ ಆರ್ವಿ?
No, this is a very matter. This consideration before division bench. That's why.
This matter is not in consideration before division bench. That's another matter relating to DRT auction. If you succeed, not this land, not the marginal land, it is never allotted to you. How can it be part of it? The marginal land has been auctioned.
Annexure B, page number 22. Page number 22. Right to copy 23.
This is my application of annexure B.
Annexure B, not with order. Annexure A is application. Annexure B, 22, page number. This is the ordinary order by the BDA. Right to copy not with the 23, page 23.
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರಿ?
This land was mortgaged.
Did you pay the money? Did you pay the money?
Respondent number 3 and 4 also not paid the money now. And then also me taking the shelter under the sale deed and disappearing with my possession is not 3 and 4.
Civil suit act. If they are disposing, interfering with their possession.
If it creates a problem, the ball in the court is so the BDA block, in direction to the BDA, to dispose the application.
Who are respond number 3 and 4 must have the.
And the petitioner, so 3 and 4, the purchasers.
ನಿಮ್ಗೆ ಯಾವ ಕೇಳಿದ್ರೆ ಒಂದು ಆನ್ಸರ್ ಬರಲ್ಲ. 3 and 4 are the auction purchase, and they are interfering with his possession after the purchase.
And then not to allow the marginal land at 3 and 4.
So you want to use the process of this court to create problem to the auction purchasers. You cannot claim for marginal land, Mr. Ravi. Marginal land goes with that site, whoever is the owner. You won't have any independent right.
Case number 24, negotiate. He responded 3 and 4. He had my back door. Okay, in order. Finish your case number 24. Did you see? The operating portion now.
Yes.
Case number GP6 in order. On the first line, 26. First line.
Yes.
In particular, Annexure C issued in favor of Joseph Branch, predecessor in taking of petitioner and asset. This factors was subject to this 1, 3 and 4, open the order you want. Can you see? This was order was remanded.
Yes.
At 28. Point number 3. The matter is submitted back to the respondents to reconsider the claim of the petitioner official and fix the writing value of the marginal land allotted in favor of the petitioner or allotment and will be a court against the 15. Bearing in mind the documents produced by the petitioner in movie and to see in the 10.6 and 3 months. This are open behind one back in order. That is to participate in the proceedings for another nobody going to to participate in the proceedings, nobody PDA. Because you have to issue to me or not. There is the present record in order now. Joseph Branch is the petitioner.
You want to withdraw, or you have to impose cost on. ಆಮೇಲೆ ಹೇಳ್ಬೇಡಿ ಶುರು ಮಾಡಿದ್ಮೇಲೆ ಡಿಕ್ಟೇಷನ್. ಇವಾಗ we are only giving you that option. You won't take it as a right. Yes. So, petitioner is before this court seeking for the following reliefs. The petitioner claims to be the owner of that is why we told you don't have to live in. The petitioner claims to be the owner of site number 261. There being certain marginal land beside the said site number 261. The request was made for allotment of marginal land to the BDA, which was considered by the BDA, and the allotment was made on after arguing, because adverse order is being passed, you can't take an adjournment. That's why you can, if you want, you can withdraw. Otherwise, we are passing the order. You can't ask like that. After arguing for some time, then it comes for the petitioner seeks permission to withdraw the above petition with liberty to approach the BDA after disposal of the petition number.
Next to the meeting number in order. 23,919/19 and the meeting number 3414/2022 and 3440/2022.
Reserving such liberty, the petition is dismissed as withdrawn. Can we please advise your client properly in this matter. The kind of letters which you have sent, action needs to be initiated against your client. Yes, so you want to, then you do it there, not sending letters like that. You produce those annexures. Please advise your client appropriately. This is not the way to write letters to the authorities. Dispose. Shri M.N. Sudhay Vegde is no longer on the panel of the respondent video. Then Shri Manjunath K is directed to accept notice for respondent. Counsel for the petitioner to serve a copy of the petition along with annexure on the said counsel. Objections, if any, to be filed on or before 7/7/2022, released on 12/7. Please serve it on him fast.
Connected matter, Gopal Bilan Madam.
Gopal Bilan.
Connected matter.
Gopal Bilan. Manjunath. Gopal Bilan. Where is Mr. Gopal? Is not here. ಅವರು ಇಲ್ಲ ಅಂತ ಇವಾಗ. So Manjunath K. Shri Gautam Bharadwaj is no longer on the panel with response. Gautam Manjunath K is directed to accept notice, furnish copies. Okay, 12/7. Mr. Ashwin. Serve ಮಾಡಿದ್ದೀರಾ? Mr. Ashwin serve ಮಾಡಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ ಮೆಮೊ? ಮೆಮೊ ಇಲ್ಲಲ್ಲಪ್ಪ. Does it have the acknowledgement? Or acknowledgement? Though Shri Ashwin already has been served, none appears. If none were to appear for respondent number 2 on the next date of hearing, the matter will be taken up for consideration in their absence. Released on 28/6. Chodal. Mr. Ullal, please unmute yourself.
My lord, I've just received. I'll file wakalat, my lord.
Just received andre yavaga?
Means the officer told me, my lord. I'll just on the next date I'll file my.
Shri Gautam Ullal seeks for one more opportunity to file a statement of objection. Objections, if any, to be filed on or before 29/6/2022, released on 5/7. Yes.
My lords, I appear for respondent number 2 in this matter.
Madam, myself from Jaina Kutari, public interest litigation, club together, we are having a talk. We have arrived at a conclusion, but we have to have a talk with the BDA to retain it as a place, public park. Madam, we were having a talk, both of us. We'll talk
In fact, I have, my lords, in fact, mentioned to me last time that whatever affidavit to be filed should be filed by the next date. In fact, we contacted the BDA counsel, Mr. Unnikrishnan, as well. Now, Mr. Unnikrishnan, I don't know whether he's present today or not, because he was also in principle supportive of the fact that this should be left as a park.
So what is the settlement arrived at, madam?
The settlement, if I may submit, settlement is ultimately this civic amenity site be left as a public park.
So are you filing an affidavit today in that respect?
No, BDA has to file.
My lord, am I audible, my lord?
Yes.
My lord, we have sought instructions from the BDA, my lord. We have received information that such a decision has to be placed before the board. And it would take about 2 weeks' time, my lord. If this matter may be posted for the end of the month, the BDA will clear its stand, my lord. It has to be placed before the board.
When is the next board meeting, madam?
My lord, we have to, after today's matter, we have to send a letter to the BDA, my lord. It shall be done by the end of this month, my lord.
So we record that both of you agreed that the subject land will be retained as a park.
Yes, sir.
Yes.
Jaina Kotari, learned senior counsel, and Srimati Pramila Nesargi, learned senior counsel. Srimati Pramila Nesargi, learned senior counsel, appearing for the petitioner, and Srimati Jaina Kotari, learned counsel, appearing for the respondent number 2, submit that both of them have agreed for the land in question to be retained as a park. On behalf of Mr. Unni Krishnan, learned counsel for respondent number 1, it is submitted that a proposal to this respect, in this respect, will have to be placed before the board of the BDA, which would have to pass necessary orders. She submits that given 2 weeks' time, the same would be placed before the board and board would pass necessary orders. Released on
first week of July, my lord.
5/7/2022 to place the resolution of the board of the BDA before this court.
Grateful.
$64, your lordship, connected matters. I appear for 556 and 12730, your lordship.
Where is Mr. Lakshman? ಬಂದಿಲ್ಲ ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ ಪಾಸ್ Lakshmesh, you are appearing in the 65.2. You appear up.
Whether a land user is entitled to an estate, whichever is initiating the acquisition of the building, he is entitled to the same extent of the land. This has been by a little bit of dispute and also affects both. Same extent is entitled. Now the anyway my learned as attendance pointed out, all other matters are posted on 28 and prepared to give if today itself and also memo of citations and also permission.
On 28th, Adunu. 65.2, Shri Lakshmesh has entered appearance for respondent number 2, registry direct, delete the name of Shri K. Krishna. The above matter, it submitted that the above matter is connected to so and so, so and so, so and so. Registry is direct to connect them and relist on 28. 230. At 230. 66 also connected, Mr.
66 is also.
Connect 66 also. WP 2001. ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ಲಿಸ್ಟ್ ಕೊಟ್ಬಿಡಿ ಇಲ್ಲ ಮೂವ್ ಮಾಡಿ ಕನೆಕ್ಟ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಲಿಸ್ಟ್ ಮಾಡೋಣ. ನೀವೆಲ್ಲ ಕೊಡಿ ಎಲ್ಲ ಕೊಡಿ. ಮೊನ್ನೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. ಮೊನ್ನೆ 1 month ಬ್ಯಾಕ್ ಬಂದಿದ್ದು. ಮೆಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ ಇದೆ ಮೊನ್ನೆ ಲಾಸ್ಟ್ ಮಂತ್ ಐ ಥಿಂಕ್. ಮೆಡ್ರಾಸ್ ಹೈಕೋರ್ಟ್ ಅದು ತಗೊಂಡು.
'67, I appear for respond number 4, madam.
Yes, Mr. Puttivala.
I have filed my detailed statement of objection.
ಹಾಕಿದ್ದೀರಾ, ಕೃಷ್ಣ ಅವರು ಹಾಕಿದ್ದಾರೆ, ಗವರ್ಮೆಂಟು ಹಾಕಿದ್ದಾರೆ. ಎಸ್ ಮಿಸ್ ನಾಗಭೂಷಣ್.
Because the now land was registered in the name of the petitioner. As per the order possible special petitioner, which was also listed at age 18.
65, huh?
18. The items of the land was registered in the name of the petitioner. The second item is survey number 49, 149, it is measuring 18 meters. There is no dispute on that.
Yes.
Survey number 149, measured totally 8 meters. 18 meters are registered in our name, 30 meters are registered in another person's name.
30 guntas in survey number 149. 30 guntas in survey number 149. What is the total extent of 149? 1 acre, 8 guntas. Adರಲ್ಲಿ third party ಗೆ 30 guntas.
These 30 guntas are purchased by Korea Cooperative Society. And when they applied for the issue of the layout plan, they have shown 1 acre 8 guntas, including our 18 guntas. Therefore, we made a representation, Your Lordship, as per the representation at annexure D, Your Lordship, page 25.
Yes.
Requesting the layout plan to be corrected by the BDA. Considering our representation, Your Lordship, BDA was seconded correction as per annexure D at page 27, Your Lordship. May read at page 28, Your Lordship.
ಉಳಿಕೆ 18 ಗಂಟೆ.
And next area, Your Lordship, it is very clearly stated.
ಸರ್ವೆ ನಂಬರ್ 265 ಅಂತಾರಲ್ಲ. ಸರ್ವೆ ನಂಬರ್ 265 ಅಂತ ಇದ್ದಾರೆ.
What has happened, Your Lordship? This word survey number is 149. We were under the impression this survey number 265, that is how we went on make a representation. That is accepted, the layout plan was corrected, Your Lordship. Layout plan was corrected, there is no dispute on that.
ಸೊ ರೀಸರ್ವೆ ಯಾವಾಗ ಆಯ್ತು?
What happened, Your Lordship? Survey number 149 became 265, that is what the impression given was by the authority. Therefore, we end up corresponding on that survey number 265. And when the property came into the jurisdiction of the Bangalore municipality, Tata also paid another name. Then you will also what happened was for the development of the temple, a portion of the property was sold to the other persons and had to do the savings also. Then what happened, Your Lordship? When by name Krishna, it appears to be a representation to the BDA, saying that survey number 265 is a Sarkari Puja called Your Lordship. That you will also get it at J1 at page 52.
Page?
Page 52.
ಅದು ಕುಂಟೆ ಅಂತ ಹೇಳ್ತಾರಾ? That is the complaint given.
Yes, sir.
No, J1 is by BD.
Party gives this notice to us. To let us ಹೊಸ ಸದನದಲ್ಲಿ 245 ಹಳೆಯ ಸದನ 140 48 ಸರ್ಕಾರಿ ಹುದ್ದೆ ಕರಾವಳಿಗೂ ಅರ್ಜಿದಾರ ಕೃಷ್ಣಪ್ಪನ ದಿನಾಂಕ 7/2003 ಇತ್ತು. ದಲಿತ ಸರ್ಕಾರಿ ಹುದ್ದೆ ಕರಾವಳಿಗೂ ದೃಢೀಕರಿಸುವ ಸಂಬಂಧಪಟ್ಟ ನಕಲು ಪ್ರಶ್ನಿಸಿತು. We were also arguing on that basis. We are called upon to give a representation. Give all the documents will do related to that your.
Yes.
Then you are also to kindly say, annexation then came to be passed by media. I am agreed by that and before you are also. Annexation is allowed. Survey number 265 refers to the Sarkari Kutte Center. It does not refer to survey number 149.
Ali number 149 ಅಂತಾರೆ.
You are also to kindly say, you are under the impression old survey number 149 is your election, but it is not so. I produce that next 60 M. This is also produced by the DBMP also. Then you will also to kindly say old survey, new survey number 265 refers to old survey number 147. Our survey number is 149. And this old survey number
149 though 149 RTC ಅಲ್ಲಿ 265 RTC ಅಲ್ಲಿ.
RTC ಹೋಗಿಲ್ಲ ಇವಾಗ because it has come to the judicial right of the law.
ಆವಾಗ ಇವತ್ತಿಲ್ಲ.
Then you will also to kindly say grant of occupancy right to be survey number 149 in respect of 3
is not in dispute.
That is not challenged by anybody. And 30 Gupta for allotted to somebody, occupancy right to somebody, some other person, he has sold it to Kalyan Corporation, there is no dispute on that one. Only Krishna gives a representation 265. If 265 corresponds to vote survey number 147, my occupancy right as survey number 149 is not disturbed. And without considering that you are also, PDA, to last endorsement given to me earlier, and gives a direction that the construction rate should be demolished without giving even a personal area. Now we are also from the annexure M1 I have produced before your lordship. It is very clear that
So it is 147.
annexure M1 and DPMP which has filed objections to this. They have also produced this your lordship.
Yes, Mr. Krishna.
Society including this survey number 149.
Michael Matar.
Including this survey number 149, measured in the 1 acre 80 guntas, and they have acquired the property and their plan was sanctioned. Thereafter, madam, we came to the some of the complaint, madam, we have came to the notice that the complaint was that madam, the petitioner and the society, by selling together, they are importing the land and selling the farming the site and selling to the third party. Therefore, madam, we issued the notice to the petitioner also, seeking their reply. Thereafter, madam, we have also verified from the Tahsildar and revenue.
Has any hearing been provided? Has any hearing been provided? You asked for the details as per annexure. The show cause notice as per annexure J1 portrait. Page 52. They replied as per J2 and K1. You passed the order as per annexure L. Is there a hearing which has been provided?
But here, survey number 265 and survey number 149, both are different. One is in the eastern side, one is in the western side. Both are survey number different survey number.
Even your order does not speak of 265, 149, 147.
The report of the revenue authority produced the
Annexure M1 Bakara 147, old number 260, new number 265.
layout plan, both are different side. One is in eastern.
Layout plan mistake is one in revenue records Bakara. Village map.
Village map.
149 east allida, 265 west allida. ಸೊ ಯಾವಾಗಲೂ ಇದಾಗಿಲ್ಲ, ರೀಸರ್ವೆ ಆಗಿಲ್ಲ. 4D ಆಗಿ ಹೊಸ ನಂಬರ್ ಕೊಡ್ತಾರೆ. But hearing has to be provided along.
Apart from hearing, now the document produced by the and the corporation also has produced the same document. To show that whosoever number 265 corresponds to whole survey number 147. My survey number is 149.
ಇಲ್ಲಿ 265 140 ಸೀರೀಸ್ ಹತ್ರನೇ ಇಲ್ಲ. 265 already exists. So if the 265 already exists in 4D ಆ ನಂಬರ್ ಕೊಡಕ್ ಆಗಲ್ಲ. ಅದೇ ಕುಂಟೆ ನಿಮ್ಗೆ ಹೇಳೋದು ಬೇಕಾಗಿಲ್ಲ. 149 ಇವಾಗ ರೀಸರ್ವೆ ಅಂದ್ರೆ 4D ಆಗ್ಬೇಕು. 4D ಆದಾಗ್ಲೇ ಹೊಸ ನಂಬರ್ ಕೊಡೋದು.
ಹೊಸ ನಂಬರ್ ಯಾವುದು ಅಂತ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. Here and it 265. Now the document I have produced, the detail case produced the document. This show that new survey number 265 is given to old survey number 147, not to 149. Therefore, the government is clarified what.
Mr. Puttegowda, you are on mute. Mute ಅಲ್ಲಿ ಇದ್ದೀರಾ. Unmute ಮಾಡಿ.
ಮಲ್ಲಾಡ್ annexure R1 ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ತಾವು ದಯಮಾಡಿ ನೋಡಿ. Page 10. It commences page 10 annexure R1. Serial number 38. Survey number 149. 1 acre 8 ಗುಂಟಾಸ್.
ಹೌದು.
ಆಮೇಲೆ ಅದರೊಳಗಡೆನೆ page 13 your last page ಕಂಡಿಸಿದೆ. Serial number 73.
265.
260. Both survey numbers are different. And one more document, kindly see annexure R7, my lord.
R7,
R7, page 24. This is issued by Special Deputy Commissioner. Last para. ತಹಸೀಲ್ದಾರ್ ಬೆಂಗಳೂರು ಉತ್ತರ ರವರಿಂದ ಉಲ್ಲೇಖ 2 ವರದಿ ಪಡೆಯಲಾಗಿತ್ತು. ಸದರಿ ಕೆಂಪಾಪುರ ಅಗ್ರಗಾಮ ಸರ್ವೆ ನಂಬರ್ 565 ಮತ್ತು 149 ಜಮೀನು ಒಂದೇ ಜಮೀನಾಗಿರುವುದಿಲ್ಲವೆಂದು ಸಲ್ಲಿಸುವ ವರದಿಯನ್ನು ಇದರೊಂದಿಗೆ ಲಗತ್ತಿದೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರ ತಾವು ದಯಮಾಡಿ ನೋಡಿ ಸರ್.
ಎಲ್ಲದರಲ್ಲೂ 149 265 ಬೇರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಬೇರೆ. Therefore, there is a serious dispute with regard to the identification of the property. Writ petition is not maintainable. Even R9, your last page kindly see page 26.
There are annexure L orders have been passed without affording an opportunity of hearing. And annexure L, before the orders have to be passed, the authority should have made a reference to this 265 ANO, 149 ANO, 147 ANO, 147 ANO. ಅದೆಲ್ಲ ಮಾಡಬೇಕಾಗಿತ್ತು.
ಅಲ್ಲ, ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ they are not disputing it.
Both of them are two different survey number, and that is why this document at annexure M1 also seems to be doubtful.
Yes.
M1 is also same document also and annexure R3.
R3. ಅಲ್ಲ, R3 ಬೇರೆ. R3 M1 ಬೇರೆ ಬೇರೆ.
R4 will not be there.
ಎಲ್ಲಿದೆ? ಖಾಲಿ ನಂಬರ್ 185 147 ಬರುತ್ತೆ. 265 ಎಲ್ಲಿದೆ? Survey number 265 R4. We will remit the matter, Mr. Krishna.
ಆದರೆ ನೀವು ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿದ ರೆಕಾರ್ಡ್ ಆಫ್ ರೈಟ್ಸ್ ನಲ್ಲಿ ನಮೂದಿಸಿದ ಸರ್ವೆ ನಂಬರ್ 265ಕ್ಕೆ ಹಳೆ ಸರ್ವೆ ನಂಬರ್ 140 ಇರುತ್ತದೆ. ಆದರೆ ಸರ್ವೆ ನಂಬರ್ 265ಕ್ಕೆ ಈ ಕಚೇರಿಯ ದಾಖಲೆಯಲ್ಲಿ 147 ಹಳೆ ಸರ್ವೆ ನಂಬರ್ ದಾಖಲಿಸಿತ್ತು. ಈ ದಾಖಲೆ
we'll remit it back to the authority. Let the authority give them an opportunity of hearing. Let the authority give a finding on this survey number. ಇವಾಗ ಎಲ್ಲಿ ಯಾರು ಮಾಡಿರೋದು ಆರ್ಡರ್? How did you pass the resolution without? How do we remit it to the customer? You get all the details from them and you pass orders. Separate ಅಂತಿದೆ, ಅವ್ರ ಕಂಡೀಷನ್ ಸಪರೇಟ್, ಬಟ್ ಅವ್ರು ಹೇಳ್ತಾರೆ 147ಗೆ ನಮ್ಗೆ 149 ಇಲ್ಲ ಅಂತ. ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ಹ್ಯಾವ್ ಟು ಬಿ ಫ್ಯಾಕ್ಚುಲಿ ವೆರಿಫೈಡ್. Petitioner is before this court seeking for the 1915 1907 vacant. Petitioner is before this court seeking for the following release. The petitioner is aggrieved by the resolution dated 27/9/2014 passed by second respondent BD at Annex L. The perusal of the said Annex L indicates that though a show cause notice had been issued and the petitioner had replied to the same, there is no opportunity of hearing which had been provided to the petitioner. That apart, the resolution does not indicate consideration of any revenue documents and or securing of any documents and or report from the concerned revenue authorities. More so when the dispute relates to the existence or otherwise of a particular survey number and or the identity of the property which is in question. It was what required before the resolution at Annex L was passed that necessary inquiry into these aspects was to be made. Hence, matter is remitted to the
ಅಲ್ಲ ನಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಒಂದು ಸ್ವಲ್ಪ ನೋಟ್ ಮಾಡಿಬಿಡಿ.
Second respondent, the second respondent shall consider shall provide an opportunity of hearing to the petitioner, as also call upon the jurisdictional Tahsildar to submit the necessary jurisdictional revenue authorities to submit the relevant revenue records, as also to consider the objections and the representation made by the Rural Bangalore Mahanagarpalika in respect to the said property and pass a detailed and reasoned order. The entire process to be completed within a period of 5 months from date of receipt of a copy of this order. Petition stands. 68. ಏನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತೀರಾ ಏನು? It's your choice. Subsequent purchaser to the notification. None appears for the petitioner. Sri M.V. Charity, learned counsel for the respondent, to submit that the above petition is not maintainable since the petitioner is a subsequent purchaser and cannot maintain the present petition. To give an opportunity to the petitioner to respond to the same and make and address arguments. released on 5/7/2020. Shri Keshav Agnivatri is no longer on the panel of the respondent. Shri Basraj HT is directed to take notice for respondent. Counsel for the petitioner to serve a copy of the petition on Shri Basraj HT by end of this week. Objections, if any, to be
Appeal for the respondent, Your Lordship.
MS Sudhir is no longer. Shri Kiran CV has entered appearance for respondent. Delete the name of MS Sudhir Vegde.
Lordship, kindly repeat on it, Your Lordship. This petition will not survive.
Petitioner Barlila and only non-prosecution, not on merits. None appears for the petitioner today also. Last time Bandilla, Adringano Bandilla. For the petitioner today also, none has been appearing for the petitioner. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to be dismissed for non-prosecution. Released on 28/6. Petitioner Barlila and only non-prosecution, Mr. We can't pass orders on merits.
Because he has been given already alternative side, Your Lordship.
We'll record your submission and dismiss it for non-prosecution. File, Mr. Charity. This is second list. Time fix made. The MV Charity seeks none appears for the petitioner. The MV Charity seeks for and is granted 2 weeks time to file a statement of objection. Objections, if any, to be filed on or before 7/7, released on 12/7. None appears for the petitioner. Mr. Krishna. Objection is filed. Anything survives? But yaru barlilla andre eno survive agalla anta. None appears for the petitioner today also. If none were to appear for the petitioner on the next date of hearing, the petition will be liable to dismiss for non-prosecution. Released on 5/7. Petitioner ಬರ್ತಾ ಇದ್ದಾರೆ. None appears for the petitioner today. None appears for 2 weeks time. It is granted to the respondent to file objections. Objections, if any, to be filed on or before 6/7/2022. Released on 12/7. None appears for the petitioner today. Released on 5/7.
Appearing for response 3 and 4.
Sungay, you are appearing. Shri T.P. Rajendra Kumar Sungay has entered appearance for R2. Delete name of Shri K.N. Puttegoda. Objections file ಆಗಿದೆಯಾ? Mr. Nityananda, what about you? You want to file any objections? ನೀವು ಹಾಕ್ತೀರಾ? What about you, madam?
Lord, I'll seek instructions and file objections, my lord.
None of the respondents have filed their objections. 2 weeks time is granted finally to file objections. Objections, if any, to be filed on or before 6/7/2022. Released on 12/7. Interim order earlier granted is extended till next day.
I appear with the petitioners in this matter, my lords. Request for a week's time to be granted. We have filed objections to the impeding application.
Who appears for the respondent now in the first matter?
The list shows Mr. Puttigowda, my lords.
I appear for second respondent.
You appear, Mr. Puttegowda?
Yes, ma'am.
Puttegowda is entered appearance for respondent number 2. Delete the name of Sumangla Gachinmat as that appearing for respondent number 2. What is this impleading application? Mr. Puneet?
Miss Hunni Swamapa 1 has filed it, my lords. We filed our objections to the same on 4th of July 2019.
The expedition is regarding the conduct of the exhibition and the tender of the contractor under BDM. He claims that BDM does not take the amount and without the that was this contention and the seeking for election for that. Then what happened was the BDM given 2 acres of land to the BDM for road widening. Instead of carrying out the work in the allotted land, in order to get the benefit of the department which is adjacent to that land, which is belongs to the contractor and the petitioner in the second. He carried out the road work in that when we started road work, money was stopped there. The BDM decided that we have not carried out the work, therefore we are not doing.
You have filed your objections. Why different councils?
My lord, we're appearing in 8017 and 8018. There is another
Yeah,
matter.
you are for whom?
For the petitioners in these matters.
Yes, what do you have to say?
My lord, I just request a week's time, my lords. We have filed our objections to the impleading application as well.
Learned counsel for the petitioner seeks for and is granted a week's time to get ready and address arguments.
Yes,
Released on 28/6.
there's an interim order, I think, in
Made clear that no further adjournment would be granted. Interim order earlier granted is extended till next date of hearing.
yes.
Serial number 7, I represent.
Readings complete ಆಗಿದೆಯಾ Mr. Puttegowda? Have you filed your objection?
ಇಲ್ಲಿ dispute between BDA and petitioner.
ನಿಮ್ದೇನಿಲ್ಲ.
ನಮ್ದೇನಿಲ್ಲ. They are questioning Annexure G issued by BDA.
None appears for the petitioner. Shri Basuraj ST seeks for and is granted 2 weeks time to file a statement of objections. 3 weeks time to file a statement of objections. Objections if any to be filed on or before 7/7, released on 12/7.
Yes. Alex Pereira fail लेकर गया. Alex Pereira fail किया.
हाँ.
बस यहाँ पे होगा देखो.
हाँ ಹೇಳಿ. Yes ಹೇಳಿ. Not in the panel. It's submitted that Ms. M.V. Tanuja is no longer in the panel of respondent number 2 and 3. Shri K. Krishna is directed to accept notice for respondent number 2 and 3. Registry is directed to print his name and delete the name of Srimati M.V. Tanuja. Secure records. Shri Ajay Kumar seeks to and is granted 3 weeks time to file a statement of objection. Objections if any by 7/7, released on 12/7. Learned AGA is directed to secure the records relating to the matter. Nivyarga. You're for Mr. B.S. Sachin. So B.S. Sachin accepts notice for respondent number 1 and 3 also. Objections ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿದ್ದೀರಾ. None appears for the petitioner. Released on 28/6.
Lord, I appear for the respondent BDM, my lord.
Yes.
I appear for respondent BDM, my lord.
Have you filed your objections?
Yes, my lord. I have filed my objections on 22nd September 21.
Ready?
22nd September 21, I have filed my objections.
You are ready with your arguments?
I am ready, my lord.
None appears for the petitioner, though the counsel for the respondent is present and ready for address argument. ಬರ್ತಾ ಇದ್ದಾರಾ? Relist on to give one more opportunity to the petitioner to be represented. Relist on 28/6. None appears for the petitioner. 3 weeks time is granted finally to the respondent to file statement of objection. 7/7/12/7.
Appear for the respondent.
R2 is also BDA. Please, Kiran CV access notice for respondent number 2 also. Readings are complete, Mr. Kiran?
No, sir. That's why I'm not referring the objection. Please type it.
3 weeks to file objection. Objection if any by 2 weeks. Objection if any by 36. Relist on 5/7. Interim order earlier granted is extended till next week. Readings complete. Ready? 13 readings are complete. Released on 5/7. Complete 3 weeks, sir. 3 weeks by 7/7. Released on 12/7. None appears for petition. Allotina owner. Para 91 subpara. In your para 91 subpara ಏನು ಹೇಳಬೇಕಲ್ಲ. The petitioner is before this court seeking for the following release. The coordinate bench of this court in so and so. Committee ಹೋಗ್ಬೇಕಿದು ಅಲ್ಲೋದು. As appointed committee so and so in terms of para 91 Roman blank. In view thereof, I pass the following out. Same matter. Yes. ಅದೊಂದು ಬರ್ದು ಕೊಡ್ತೀನಿ. Reading computer. Mr. Unni Krishnan. None appears for both parties. Readings are not complete. 3 weeks time. 2 weeks time is finally granted to the respondent to file statement of objection. Objection is written by 30th. Released on 5/7. ಯಾವ ಫೈಲ್ ಮಾಡ್ತೀರಾ ಮಾಡಬೇಕಾ 2 weeks time to file objection. Objection is only by 36. Released on 5/7. ಹಾಕ್ಬೇಕಾ ಇಷ್ಟೆಲ್ಲ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಎಲ್ಲಾನು ಇವಾಗ ನಿಮ್ 21 Lakshmi, none appears for the petitioner. Shri Lakshmi Shah seeks bond is granted 2 weeks time to file statement of objection. Objection is by 30th June. Released on 5/7.
Site was allotted. He has to purchase from the allotted. Now some third party was allotted. They have imposed that the public construction. They have filed the suit of the suit is pending. Now they are seeking to
landowner probably
the earlier landowner.
Yes.
From whom the land was acquired. From whom the land was acquired.
Then
if it is the earlier landowner, then you have to take care, Mr.
You are the side of the Current to sell this.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ? ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Page 4 ಮೇಲೆ para 4.
Page 4 7086. ನೀವು ಕೊಟ್ಟಿರೋದು ರಾಂಗ್ ಕೊಟ್ಟಿದ್ದೀರಾ. 6012.
After purchasing this website, the purchaser has traditionally in the local possession and intend to construct building into the said site. When this petitioner went to the spot and came to know that the landlord has made this and fenced the above allotted site, and there is no access to go to the spot.
OS number ಲ್ಯಾಂಡ್ಲಾರ್ಡ್ ಅಂದ್ರೆ ಯಾರು? ಬಸವರಾಜಪ್ಪ ಕೆ ಎಚ್ ಇಲ್ಲ?
Now the original actual landowner, he put up the fence to the ingress and egress area, and suit is pending.
You should take action against the erstwhile owner, Mr. Krishna. Really, you as authority who is acquired. After having acquired the land, allotted site formation, and if they do it, then you also have a duty to play. Suit ಆಗೋವರೆಗೂ ಇಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕು? ನಿಮ್ಮ ಮೈಂಡ್ ಮಸ್ಟ್ ಕನ್ಸಿಡರ್ ಅನೆಕ್ಷರ್ ಎಲ್ಲಿ ಏನ್ ಬೇಕು ನಿಮ್ಗೆ? ವಾಟ್ ಡು ಯು ವಾಂಟ್? ಕಮಿಟಿಗೆ ಏನಾಗುತ್ತೆ? Is there any writ petition filed by the erstwhile owner challenging the acquisition? No. If that was there, we could have referred to the committee. Our writ petition we could have referred. Not
he sold the property inside in Basraj. And the Kappa has been issued with Basraj, my previous vendor. And then you make identity.
But you have to come up with how to safeguard the interest of the allotment. ಅಲ್ಲ, ನೀವು ಅದೆಲ್ಲ ಹೊರಗಡೆ ಮಾತಾಡ್ಕೊಳ್ಳಿ. ಇಲ್ಲಲ್ಲ, ಇಲ್ಲಿ ಈ ಕಡೆ ಆ ಕಡೆ ಅಲ್ಲೇ ಮಾತಾಡ್ಬೇಕಂದ್ರೆ ಅಲ್ಲಿ ನೀವು OS ನಂಬರ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿದಿರ ಪ್ಯಾರಾ 4. ನಿಮ್ ಪ್ಯಾರಾ 4 ನೀವೇ ಓದಿ. ನಂಬರ್ ಹಾಕಿಲ್ಲ, OS ಅಂತ ನಂಬರ್ ಅಂದ್ರೆ ಹಾಕಿದೀರಾ ಅಂತ ಅರ್ಥ. ಫೈಲ್ ಮಾಡಿರ. Verify and make a statement as to whether you have filed a suit or not. Shri Vasant Kumar, Learned Counsel for the petitioner, seeks for and is granted a week's time to ascertain and make its submission whether the original suit has been filed or not and the status thereof. He is also directed to furnish the suit number if filed to Mr. K. Krishna, Learned Counsel for the respondent. We list on 28/6. Who is appearing now? Shri Ganapati Shastri has entered appearance, registry direct delete the name of Shri D.V. Nagakrishna. Agbeka. Shri Lakshmi Rao seeks for and is granted 2 weeks time to file a statement of objection. Objection is any by 36, released on 5/7. Shri Manjunath LK has entered appearance, delete K. Krishna. None appears for the petitioner. Shri Manjunath LK seeks for and is granted 2 weeks time. File objection by 30, released on 5/7.
My lord, for 1 week's time, I'll file my statement of objection.
Bottom day was C. Ullal has entered appearance, delete K. Krishna. Statement of objection 36, 6%, 57. Dear Sachin, delete K. Krishna. None appears for the petitioner. Objections 2 weeks, 30, 57. What do you want? What is the representation? Annexure F is at page number? Alternate site bet on 40-60. You want 40-60. Yes, all the records. Petitioner is before this court seeking for the following use. The petitioner's father was the owner of land in survey number 96/2, measuring 5 acres 30 quintals. Survey number 98/2, so on, so on, so on. The land of the petitioner was acquired for the purpose of formation of the Sarakti layout in the year 1979. 79 ಆದ್ಮೇಲೆ ಇವಾಗ ಬರ್ತಾ ಇದ್ದಾರೆ. ಏನು ಬರಲ್ಲ ಬಿಡಿ, ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ, ಇನ್ನೊಂದು ರೌಂಡ್ ಬರ್ತೀವಿ. The contention of the petitioner is that upon the acquisition of the aforesaid land, the petitioner is entitled to sites in the layout and as per the 40-60 scheme formulated by the BDA. You are not entitled for this. 40-60 scheme. It is in view thereof that a representation as Annexure F dated 15/4/2021 has been submitted by the petitioner, which is not yet been considered by the respondent, and as such the opposite reliefs are sought for. Shri Suraj Patil, learned counsel appearing for the respondent, submits that given a period of 6 weeks' time, the representation will be considered strictly. 8 weeks' time, the said representation will be considered strictly in accordance with law and necessary orders passed. Placing a submission on record, the petition stands disposed. Proceedings are complete. Learned counsel for the petitioner seeks from is granted 2 weeks' time to get ready and address his arguments. Released on 5/7.
I appear for the petition in this case, my lords. For the defendant, respondent, my lords. My lords, 3 weeks' time may be granted, my lords. We will file our statement of objection, my lords.
Counsel for the respondent seeks for and is granted 2 weeks' time to file objection. Objection if any by 30th. Released on 5/7.
Obliged, your lord.
Appearing for petitioner in this case, my lordship. Lord, it is a writ of mandamus.
Mandamus.
Petitioner was allotted a site. Yes.
Two weeks' time to file a statement of objection. Objection if any by 36. Released on 5/7. So Ramakrishna, Ramakrishna or Bandila. None appears for the respondent. 2 more weeks' time is granted finally. to the respondent to file a statement of objection. Objection is by 36, released on 5/7. Mr. Unnikrishnan, file ಮಾಡಿದಾರಾ? None appears for the respondent. 2 weeks time finally. 5/7. 36. Complete. You filed your objections. Yeah. Ready? Ready, madam? How long will it take to consider it? Not specific, alternate site in accordance with law. Petitioner is before this court seeking for the following release. The petitioner was the owner of revenue site number 32, formed in survey number 14/3, measuring 14/3 of Giddana Konnayanalli village, Yeshwanthpura Hobbli, Bangalore North Taluk, measuring about 30 by 40 feet. And purchased the same in the year 1992. The said land, along with other land, was acquired for the formation of Sir N. Vishweshwaraya layout. The petitioner, relying on the representation resolution submitted. The respondent is stated to have passed an order on 11/11/2020, agreeing to allot an alternative site to the petitioner. Thereafter, letters were also issued by the Deputy Secretary 1 on 16/4/2021, but no action was taken. Hence, the petitioner has made a representation on 12/7/2021 to allot an alternative site. Despite the same having been submitted, no order has been passed by the respondent till date. When counsel for the respondent submits that due to the COVID pandemic, no orders could be passed, but however, given a period of 8 weeks, you are COVID ill, 8 weeks time, necessary orders will be passed on the said representation in accordance with law. Placing the said representation on record, the petition stands disposed. File ಮಾಡಿದ್ದೀರಾ? None of the petitioner released on 5/7. Yes, Mr. Basraj. ಮಾಡಿದ್ದೀರಾ? ಹಾಕ್ಬೇಕಾ? Basraj, none appears for the petitioner. The counsel, Shri Basraj ST, seeks bond is granted 2 weeks time. File objection 36/5/7.
We appear for respondent.
CV accepts notice for respondent number 1 also.
And place date to file the objection number.
Objections 36/5/7. Wherein AGA accepts notice for respondent number 2. Counsel for the petitioner to serve copies on the learned AGA. None appears for the petitioner. Shri Vachan seeks for 2 weeks time. 4 weeks I guess. 21. ನೋಡಿ ಏನಾಗ್ತದೆ 4 weeks ಅಲ್ಲ 3 weeks maximum. 3 weeks time. Granted to file objection. Objection is any by 7/7 released on 12/7.
serial number 36, I am appearing for petitioner in this case.
Yes.
My lord, it is a writ of mandamus. A site was allotted, but there was a delay in payment of the money, my lord.
Your payment ಮಾಡಿದೀರಾ?
ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, and with interest also we are ready to pay ಅಂತ we have given a representation.
Collect interest and do it in accordance ಅಲ್ಲ. ಇವಾಗ ಮತ್ತೆ ಆರ್ಡಿನೇಟ್ ಬೇರೆ ಎಲ್ಲ ಏನು? Petitioner is before this court seeking for the following relief. The petitioner was allotted site number 158 measuring 20 by 30 at Nanbarthi, bracket Vallegaralli, second stage, for a price of rupees 58,977. Though the petitioner has made payment of substantial amount of money, the petitioner and 59,000 ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತೀರಲ್ಲ?
ಇಲ್ಲ,
59,000 ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೀನಿ ಅಂತೀರಾ?
Yes, my lord, I have produced the DDs, my lord, Annexure D, page number 8.
Balance ಏನು ಉಳಿತು?
ಅಲ್ಲ, it is late payment, my lord.
The petitioner, though has deposited a sum of rupees 59,000 towards the same, the deposit was made belatedly. Despite the petitioner having approached the respondent for the execution of the necessary registered sale deed, the respondent has been delaying the sale. It is in that background the petitioner has approached this court seeking for the office of the deed. It is not in dispute that the allotment was made and that the petitioner has deposited the entire amount. In my considered opinion, the ಬೇರೆ ಯಾರಿಗೂ ಅಲಾಟ್ ಮಾಡಿಲ್ಲಲ್ಲ? In my considered opinion, for the delay period, the respondent would be entitled to interest at the rate of, as per another 12%, as per the rule. Rule ಯಾವುದು? Allotment of site rules ಅಲ್ಲಿ rule number. So Krishna, what is the rule for interest delayed payment? 13 or 1984 rules. Site rules. Rule 13 relating, Rule 13 of the BD allotment of site rules 1984 relating to condition of allotment and sale of site. Neither thereof I pass the following. Writ petition is allowed. The respondents are directed to consider the representation of the petitioner dated 1/10/2020, collect interest, if any, on the delayed payment and execute necessary sale deed in favor of the petitioner within a period of 8 weeks. 12 weeks from today. The current CV access notice for respondent number 1 and 3 also. Yes, Mr. Kiran?
Next time we will actually final objections to this.
You want to file objections? Shri Kiran seeks for and is granted 2 weeks time to file a statement of objection. Objection by 36 released on 5/7.
My lords, I appear for the respondents.
Yes, Mr. Karthikeyan.
May I make one submission, my lords. My lords, yes. To break become infectious for the reason, my lords, the representation or the letter that has been submitted to the respondent has become infectious for the reason subsequently a contempt was filed and the contempt has also been dropped, my lord. I only request that the petitioner make another submission, another representation, which would be considered, my lord, within a period of 8 weeks.
Vasan Kumar, ಈ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕಂಟೆಂಪ್ಟ್ ಹೋಗಿ ಕಂಟೆಂಪ್ಟ್ ಎಲ್ಲ ಆಗೋಗಿದೆ ಅಂತ ಇನ್ನೊಂದು ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಡಿ ಅಂತ
this court has already given direction to cancel to revoke the cancellation order and to execute the sale.
Then you place those records. He wants to argue. You place those records on the.
Please, 2 weeks time.
The applicant seeks for and is granted 2 weeks time to file a statement of objection. If any, 3657.
Please, great.
Certified. ಎಲ್ಲದರಲ್ಲೂ ಹಾಕ್ಬೇಕು ಅಂತ ಇದ್ರಲ್ಲಿ ನೀವು 3657.
That cannot be considered because the petition has only
Place it on it.
not on the ground now.
We will consider the ground once it places it on it. 3657. Place all of it on it. Objection ಆಗಿದೆಯಾ? Released on 28/6. Proceedings are complete. Released on 28/6. ಶುರು ಆಯ್ತಾ? ಸೊ ಇನ್ನು ನೀವು ಸಿಗಲ್ಲ ಇನ್ನೊಂದು ತಿಂಗಳು. ಇದೇನು ನೀವು ಒಂದು ವಾರದಲ್ಲಿ ಅದು ಮುಗಿಸೋಲ್ಲ, ಮತ್ತೆ ಇನ್ನೊಂದು 100 ಸೈಟೇಷನ್ ಬರುತ್ತೆ ಅದ್ರಲ್ಲಿ. ಸೊ ಇದು ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ರೆ 24/2 ಇಶ್ಯೂ ಯು ಸೆಡ್ ಯು ವಿಲ್ ಕನ್ಸಿಡರ್. But relief you are sought for is lapsing on account of 24. So ಅದು ಇವಾಗ BDA ಬರಲ್ಲ. BDA 24/2 does not apply.
This is already a accusation judgment not the way that those who are consulted the office they can so 24
So ಯಾವಾಗ ಎಷ್ಟು ದಿನ ಬೇಕು? ವಿ ಲಕ್ಷ್ಮೀನಾರಾಯಣ learned senior counsel seeks for and is granted 2 weeks time. Released on 28/6. ಅಷ್ಟೇನಾ?
ಅಲ್ಲ ಅದೇನೋ ಅಲಾಂಗ್ ವಿತ್ ಅಂತ ಏನೋ ಒಂದು ಆರ್ಡರ್ ಇದೆ ಅಲ್ವಾ ಅದರಲ್ಲಿ ಅವತ್ತು ಮಿಸ್ ಹೆಂಗಿದೆ ಅದು ಇದು ಬೇರೆ ಎಟ್ಕೋದಿಲ್ಲ ಮೋಸ್ಟ್ಲಿ